Karen M. Kimmerite of the North Carolina Utilities Commission and presiding commissioner today. With me are Chair Charlotte A. Mitchell, Commissioners Kimberly W. Duffley, Jeffrey A. Hughes, Floyd B. McKissick Jr., William M. Brawley, and Tommy Tucker. This technical conference is being held in docket number W-100 sub 67, which is entitled, "In the Matter of Investigation Regarding Consolidation of Water and Wastewater Utilities and the Utilization of Uniform Rates." In compliance with the State Ethics Act, I remind all members of the Commission of our duty to avoid conflicts of interest and inquire at this time as to whether any member has any known conflict of interest with respect to the matter before us this afternoon. Please let the record reflect that no such conflicts were identified. On September 18, 2023, the Commission issued an order scheduling technical conference, which was later rescheduled to December 6, 2023. The purpose of the initial technical conference was to receive information from the water and wastewater utilities, as well as from the public staff, to assist the Commission in its consideration of matters related to the consolidation of small systems and the use of uniform rates. In the order, the Commission made the public staff, Aqua North Carolina Incorporated, that I'll refer to going forward as Aqua, and Carolina Water Service Incorporated of North Carolina, that I'll refer to as CWSNC, or Carolina Water, as parties to this proceeding. On December 4, 2023, the Commission granted Redbird Operating Company LLCs, that I'll refer to as Redbird going forward, petition to intervene in this proceeding. At the December 6, 2023 technical conference, the public staff, Aqua, and CWSNC presented information including, but not limited to, whether the uniform rate paradigm continues to serve the public interest in North Carolina and whether the path to uniformity should change in light of the challenges faced by the water and wastewater utilities in North Carolina. Redbird attended the technical conference but did not make a presentation. Based upon the information presented at the technical conference, the Commission determined that further discussion was warranted, both separately by the parties in stakeholder meetings and in the form of continuing updates to the Commission. Therefore, on December 21, 2023, the Commission issued an order establishing quarterly technical conferences and scheduling the first quarterly conference for this date and this time in Raleigh, North Carolina. The December 2023 order directed the public staff, Aqua, and CWSNC to participate in the technical conference and present information on various issues related to uniform rates for water and wastewater systems. The stakeholder meetings that have been held since the initial technical conference, any consensus items that have been reached, and the remaining issues of disagreement between the parties. The order provided that Redbird may participate if desired. On March 5, 2024, the public staff, Aqua, CWSNC, and Redbird filed their respective presentations, including a list of presenters. That brings us to today. We will first hear from any spokesperson for the stakeholder meetings to update the Commission on the meetings. We will then hear from CWSNC first, and then the Commission will then call upon the parties in the following order: Aqua, Redbird, and the public staff. The parties will be allowed approximately 20 minutes each to make a presentation. After each presentation, the parties will be allowed the opportunity to, the Commission will have the opportunity to ask questions of the parties if there are any. The technical conference this afternoon is being transcribed, and the transcript will be filed in the docket as soon as it is available. So before we begin, I would like for the parties to identify themselves for the record. Beginning with CWSNC.
Thank you. Joanne Sanford with the Sanford Law Office, representing Carolina Water Service, Inc. of North Carolina. And with me at council table is Matt Schellinger.
Good afternoon.
Good afternoon, Commissioners. Molly Jagannathan with the law firm Troutman, Pepper, Hamilton, Sanders, here on behalf of Redbird, and with me is Aaron Silas on the witness stand.
Good afternoon.
David Drews with Fox Rothschild, appearing on behalf of Aqua, North Carolina, and making the presentation and here today are Ruffin Poole with Aqua and Kim Joyce with the parent company, Essential Utilities.
Good afternoon.
Good afternoon, Megan Yost with the public staff representing the using and consuming public. With me at council table is Rita Coxton, and our presenter is Charles M. Junis.
Okay, good afternoon. And before we begin, are there any preliminary matters that we need to discuss?
There is one more thing that I would like to say for the record. State President of Carolina Water Services, Don Denton, who is known to all of you, and he would very much like to be here today, particularly in preference to what he is doing today, which is recovering from back surgery, which he had on Friday. So he regrets being unable to be here, but he and Mr. Schallinger have worked very closely on the company's position, and we'll be sure that it's expressed on his behalf today.
Okay, and thank you for the update about Mr. Denton.
Thank you.
Any additional preliminary matters? Okay, and with that, we'll go ahead and begin the technical conference. Before the parties provide their presentations, are we going to hear from any spokespersons about the stakeholder process?
Mr. Junis and Mr. Silas are about this.
Okay, please begin.
So Presiding Commissioner Camerite, I just want to note the parties had discussed the order here that we would present. And so Mr. Silas and I would be presenting on behalf of the stakeholders. And then we were anticipating having Redbird, Carolina Water, Aqua, and then the public staff, if that would so please the commission. I don't think we were aware of whether there was an expected order or not, but that's what we had sort of discussed amongst ourselves.
So Mr. Junis, that order will be fine. We'll hear from the two of you about stakeholder meetings, and then we'll hear from Redbird, Carolina Water, Aqua, and then the public staff.
All right, thank you very much. So just to hit on, we're not going to go through everything in our slides. I think it's available to read, but just wanted to emphasize how serious the stakeholders took this technical conference and the meetings amongst the parties. So we did meet on 3 occasions, February 6th, February 14th, and the 22nd. And attendees included Shannon Becker, Kim Joyce, and Ruffin Poole, and Charlie Baldwin from Aqua, and Donald Denton, Matthew Schellinger from Carolina Water, and Aaron Silas from Redbird, and then Gina Holt, Megan Yost, and myself, Charles Junis, on behalf of the public staff. So great group of minds. Really tried to find a consensus here. I'll just give a brief overview. We didn't do a great job of finding a consensus. There were certainly commonalities amongst the group at points, but I think just to give a general overview, the public staff really values the case-by-case analysis and sort of a little more nuance than a simple yes or no answer to some of these prompts. And so now Mr. Silas, I think, is going to run us through the commission's prompts.
Yeah, and I'll do it pretty quickly. Like Chuck said, there was not a whole lot of consensus. So I'll talk about, the fact that a lot of the companies and public staff are going to dive deeper on some of these topics in their personal presentations. Topic 1 was whether water and wastewater systems should be grouped based on similar cost of service or other similar characteristics. The companies in these stakeholder meetings kind of talked and said that the preference is for a truly uniform rate with a single revenue requirement for water and then a single revenue requirement for sewer, while public staff, I believe, kind of sees it as a little more nuanced. A whole lot more has to go into that. So I'm sure you'll hear the specifics from them during their presentation. Topic 2 was whether a transfer system can be incorporated into an existing multi-year rate plan to avoid increasing the number of standalone rate entities. Redbird obviously is not super informed about those multi-year rate plans because we haven't done a rate case yet. But Aqua and Carolina Water says yes, and public staff said no on this one after those discussions. Topic 3, I think, is where we kind of got the most consensus. This is how the commission should address the affordability issue of low-income customers when migrating to uniform rates. All stakeholders agreed that the future of LIWAP funding really impacts this response. And what you'll hear in our individual presentations is a lot of different ideas that came out of these stakeholder meetings on how to address affordability. So obviously, we all agree that it is an important issue, and we all kind of have different unique perspectives. Could be a combination of a couple of ideas, or one. But yeah, that was a really good discussion between all parties there.
And I'll just add that, I think it's sort of the brainstorming phase of trying to address affordability, that we appreciate the prompts put forth by the commission, and, the complexity of trying to operate within the current statutes, or whether it would warrant some sort of change or even a modification to the commission's rules. So I think there's some initial thought put to this, but I think there's more to come.
Definitely. Topic 4 was whether acquired systems that have a cost of service less than the uniform rate cost of service should be included in uniform rates. Companies say yes, and the public staff say no. And an additional topic was, I think directed specifically to public staff about what circumstances, if any, would lend itself to that. I don't know if you want to chat
Yeah.
now or during yours.
We can hit this just briefly. And we have ran into instances where, for example, an emergency operator acquires a system, and then we're trying to deal with the true up process. And there's a potential deficit, how to handle that, whether it should go into rate base. So there are instances that kind of shift that timing to determine some of these aspects of rate making. The other point to make is that we read this very to the point, in that it refers to a transfer. And so we were not trying to answer this question in the context of acquisitions, for example, like a CPCN proceeding. So just to keep that in mind, I don't know what the commission had in mind when they were asking this question, but we took it from a very literal interpretation of transfers only.
For topic 5, it is if the commission considers it appropriate ongoing policy, the determination of whether uniform rates are appropriate at the time of transfer will be made on a case-by-case basis, regardless of whether the cost of service for the standalone system supports such approval. There was a bit of consensus here. So the companies and public staff both say yes, with a little nuance that you'll likely hear in the individual presentations. But there was consensus on topic 5 here. Topic 6, what mechanisms would facilitate efficient transfer of small water and wastewater systems to the larger utilities? Again, this, was more of a brainstorming session than whether or not there's consensus. I think that, there was some really good conversations about potentially faster acquisition cases or transfers for troubled systems, or there was a lot of kind of brainstorming in this one as well. I don't know, Chuck, if you have anything to add there, but not necessarily consensus, I wouldn't say.
No, I think there is a recognition that, this commission regulates over 80 some water and sewer utilities, a few being quite large, and then many that may or may not fall in the definition of small. I think it depends on how you define small. I think it also depends on how you define larger utilities. So, I think there's challenges just on the front end. How do you define these terms? And then what does that mean? Are there incentives? Are there waivers? And those are some of the ideas put forth by the companies.
And then the last topic is topic 7. Should the rate base of the acquired systems be established in the transfer proceeding rather than having the rate base determination deferred to a future general rate case proceeding? Companies and public staff, besides Redbird, were in agreement that the rate base should be determined during the transfer proceeding, and then Redbird dissented from that opinion about deferral to a future rate case. And that's really all the topics. I didn't know if you guys would have any questions for us about these stakeholder meetings, but that's really kind of the overview.
Okay. Well, I'd just like to say that we appreciate the effort and the time that the companies and the public staff put into the stakeholder meetings, because these are important topics for going forward and issues that we're addressing currently. So we appreciate that. I know that we're going to be delving pretty deeply into all these topics during the different presentations, so I won't ask any questions about that. I will say that I was encouraged about the brainstorming efforts, especially about affordability, and then ways that there could be mechanisms to better incentivize or streamline the process for acquisition of the small troubled systems. And We are anticipating having an additional technical conference or information. And so I would encourage all the parties to continue with that brainstorming so we may be able to have some more consensus or ideas going forward. So I have no questions because I'm going to be waiting for the presentations, but I'll check with my fellow commissioners to see if they do. Commissioner Brawley?
Yes, ma'am. Did you two gentlemen write this document?
It was a consensus based on the conversations we had, but yeah, Chuck and I kind of took the lead in putting it into a PowerPoint presentation. Yes.
After you did this, was this circulated and approved?
It was circulated a couple times, I think. Yes, sir.
Okay, thank you.
Commissioner Tucker?
Thank you, Madam. If I ask some questions that'll be pertinent to the presentations by the water companies, you can stop me there. And I'm just going to ask Chuck a couple of things, having reviewed what they put in their report, okay? First of all, uniformity and certainty is better for business. And Chuck, you're PE, so you get down in the weeds and you look at all the technical pieces of that kind of process. But for a business, it's better to have blanket certainty. And my concern is we, as Commissioner Kimwright said, we have trouble systems that come to us for acquisitions, and the process to take them over from where I sit in just 2 or 3 months is not very streamlined. What do you see as far as being able to improve that process?
And Mr. Junis, if that is, I believe that's in your presentation, is that correct? And if so, I think that I would ask that you hold your answer, but be certain to specifically respond to it during your presentation.
Okay, perhaps I'll just wait.
Okay.
Thank you.
Okay.
I got that question noted, and we'll be ready to address that during our time. Thank you.
Okay, so thank you to both of you for the overview, and now we'll turn to Redbird for your presentation.
Thank you, Presiding Commissioner Kimwright. If it would be helpful, does the commission have paper copies of the presentations? Or okay, now we'll refrain from passing those out. And before Mr. Silas dives into his presentation, I just wanted to briefly address question 7, which was the rate-based question. And again, I know you all aren't interested in hearing legal arguments or oral argument, but just wanted to kind of provide high-level context in the stakeholder group. It appears that Redbird's an outlier, so I just wanted to give a little bit of context for that. And I think the other utilities may have a little more nuanced view of that, and I'm interested in hearing that as well. But as we're just talking about, I think everyone agrees that the public interest is served when these smaller troubled utility or systems get transferred to larger utilities that have the financial capacity to make long overdue, much needed improvements. And so I think sometimes what gets lost in the shuffle in these transfer proceedings is that the buyer of the system is pretty much at the mercy of the seller in terms of the information about rate base. And I think generally, the smaller, more troubled the system is, the worse the information they have from an accounting perspective in terms of missing documentation, incomplete or inaccurate accounting and record keeping. So I think that's just a little more context about, once the seller actually acquires and owns and operates the system, they tend to get better information about what the assets actually are and would be better positioned to present evidence on rate base in a rate case. And that seems like the best forum for the commission to set just and reasonable rates that are fair to both the utility and the customers. So with that, I'll turn it over to Mr.
Okay, and thank you. To level set before we begin, I appreciate that. And this is for the parties. I think everyone understands, and also for the commission, that some of these issues do have some overlap with pending dockets and application before the commission. And so to be very clear, we will not be talking about any pending dockets or applications. We're talking, and none of the questions that will be coming to any of the parties will be about any specific dockets or applications. And we'll be talking about these issues more at a high level policy perspective. But thank you for that perspective.
Absolutely. Thank you. Understood.
Perfect. Well, I wanted to start by thanking you guys for the opportunity to speak in front of you guys today. I think that workshops like this are really exciting and interesting to me. So thank you for, taking the time to care about issues like this. It's nice to see, and it's something that I've seen in some of the other states that CSWR affiliates operate in. So I really appreciate that. I wanted to start at a really high level and just kind of explain who we are for those who might not be super aware. So my name is Aaron Silas. I'm the Director of Regulatory Operations at CSWR, which is the parent company of Redbird, who is the North Carolina affiliate. We have a couple systems in your states with some more pending, which I will not get into, but I wanted to just kind of introduce myself first. Obviously, Redbird did not present at the last workshop, so my first couple slides are just kind of a brief introduction to our perspective into some of the questions that came up in the last workshop, and then I delve into the topics that you guys specifically wanted answers to. So the first thing here is, do uniform rates serve the public interest? Redbird believes yes. I actually just gave a presentation at NARUC a couple weeks ago about single tariff pricing and how that's really helped us with the affordability in some of our other states. So that's a lot of what my presentation is about. Obviously, in North Carolina, Redbird has not gone through a rate case. We have no multi-year rate plans, that are currently ongoing. So a lot of what I am going to talk about today is just my experience in other states, in the hope of maybe inspiring some thought or creativity in some of the mechanisms that you guys can utilize here in North Carolina. So Redbird believes that single tariff pricing and rate consolidation provides overall equity among ratepayers. Although it may appear that one system may be subsidizing another at the beginning, Redbird believes that over the lifespan of two separate systems, they would have an equal amount of investment. One of the things that made it clearer to me is, we have a 5 connection system, wastewater system, and a 500 connection wastewater system. Even if that 5 connection wastewater system requires more upfront investment to meet standards or to process the waste correctly, this larger system with its collection lines that are eventually going to need repair or replacement, that has more investment, and the consolidation of looping in that 5 connection system is going to help them even slightly in the long term whenever it comes to some of those longer term investments. So here on slide 2, mechanisms to create change, is the header here. I just kind of talk about the fact that you guys are not the only commission that CSWR affiliates are regulated by that has asked questions like this and are having ongoing conversations about. The two that come to mind most clearly are Arizona and Texas for me, and I just have some brief blurbs there, and I can provide more information later if needed. But yeah, Arizona and Texas are really looking into consolidation right now and looking at the positive benefits and really looking at how to get smaller utilities out of the industry. The developers who never wanted to be in the industry, the son who inherited it from his father, the daughter who inherited it from her grandfather, the people that don't want to be in the business, it's looking at ways to allow them to gracefully exit, right, and sell to some of the larger utilities. And then this is really the next slide is just an example of system condition acquisition. I wanted to get us all on the same page, right? This is what we're talking about. This is the kind of issue that needs to be resolved. And single tariff pricing and uniform rates really help incentivize companies to come in and take over these systems that are really poorly run, that need a lot of capital investment, that need a lot of care when running and rehabilitating. So I just wanted to kind of show that as an example. And this gets into the specific topics that we're talking about today. So the first slide that I kind of wanted to talk about is titled Grouping Based on Similar Cost of Service or Similar Characteristics. I believe that the benefits and consolidation occur when there is one single revenue requirement for water and one for sewer. I think that puts an odd kind of vision in some people's heads. But where I've seen the true creativity and the true magic happen is in the rate design after that, right? So although in a lot of these affiliated states where Redbird has completed rate cases, there is one single revenue requirement. This table off to the side is an example of some of the creative things we've done to to then split the cost based on characteristics, right? So this is an example from Missouri. We just finished a rate case in Missouri in December, and we implemented a district system where based on the type of treatment at the facility, you were placed into a lower cost district versus a higher cost district, right? So you'll see that some of the more simple treatment methodologies, facultative lagoon, and aerated lagoon are in District 1, which is the lower cost. And then some of the more complex treatment was placed in District 2, which is the higher cost. So things like extended aeration, recirculating media filters, those were placed in District 2. That's just one example. We actually have examples from a lot of the states that we operate in. In Mississippi and Louisiana, we do something very similar, except they're called tiers. So tier 1 is the lowest cost, which is really just facultative lagoons. Tier 2 is kind of what I'll call the average residential. So it includes things like aerated lagoons and some of the more complex treatments you see listed here as well. And then the third is purchase treatment. So what I like to call pass through, right? So if as an example, if Redbird purchases Lake Royale, right? We purchase water treatment there. That would be a tier 3 because we're not actually doing the treatment. We're passing that through to the customers. So that is the lowest cost because a lot of it is really just the pass through from the supplier, right? So long story short there, single revenue requirement, but that doesn't mean that we can't do some of the things that we've talked about before in the rate design, right? That brings me to the next topic, which is affordability during that migration. Obviously, we don't have, we haven't been through a rate case in North Carolina, but in some of our other affiliates, we have what I'll call regulatory assets that allow us to phase in rates. And that's what I've seen, be the most effective in some of the states we've been in for a little bit longer. Rate shock is really what we try and avoid most often. A lot of the times these systems that we acquire haven't had a rate increase in decades, and they're going from $15 a month to $40 a month. That's a Mississippi example. So what we've done in Mississippi is set up these regulatory assets that allow customers to kind of glide into that final rate, right? So at closing, we adopt the cost, the rates from the selling utility. In year 1, we bump them up to a mitigated rate, and in year 2, they go to the final rate. And the losses that occur because of that migration are kind of lumped into a regulatory asset that the company is then allowed to earn on. So in the long term, the cons of that really for the customer are a slightly higher rate because we have that regulatory asset that we're allowed to earn on. The pros are that they don't jump from $12 to $40. They're allowed to kind of phase that in. And the commissions there really saw the benefit in the long term of that, right? Very small kind of total rate increase versus the gliding path that was provided to those customers. So that's kind of our one example of how creativity can help with this affordability during the migration to a final uniform rate. The next is titled Timing and Efficiency. Basically, this is kind of trying to talk about some of the efficiencies that can be achieved through the acquisition and transfer process, right? So, from Redbird's perspective, I don't believe we'll ever really want to bring a system into a final rate at the time of closing, at the time of transfer. Generally, the systems that we acquire are really poorly run, really dilapidated, and the customers haven't gotten good service for sometimes decades. And so what we like to do is we like to come in and show that we're, a better provider. We like to show our services and what we can do for the customer prior to them ever seeing a rate increase. So what Redbird would like to do is really continue to adopt the rates at the time of closing and have them on that glide path that I mentioned before. That way customers get to see the benefits before they ever see a rate increase due to the transfer. I think that's probably not the same idea as some other companies, and I understand that. That's just kind of what we've done across our footprint in the country, and we've seen it work really well. As far as the expedited transfer process, I mean, the biggest thing for me, and Molly touched on this before, is an expedited process for distress systems, right? There are systems that are currently providing service to customers that are truly what I would call at least distressed, right? On consent decrees, sometimes not treating sewage, sometimes, sellers are kind of literally begging to get out of the industry because they don't have the funds to keep up. They can't keep a good operator. And what I would like to see is an expedited process for systems like that. Whether that's waiver requirements for some of the rules, whether that is, pushing rate-based determination until a rate case, until you can gather the necessary accounting records. I think there are a lot of ways to do that. But I think at a high level, it's really beneficial for customers to see and to get utility that knows what they're doing as quickly as possible, rather than maybe taking the full 6 to 8 months, right? And that's really, kind of at a high level what I wanted to talk about. And obviously, I want to give the rest of my time to questions. So please, any questions you have, I'm happy to answer.
Thank you, Mr. Silas. I'll begin with a few questions, and then I expect that my fellow commissioners will have questions as well. My first question relates to page 3 of your PowerPoint presentation, in which you talk about policies and mechanisms that would promote system consolidation in the country. And you specifically reference Arizona and Texas. Do you have any more specific information that you can provide about what Arizona and Texas are doing to promote these consolidations?
Definitely. I'll start with Arizona because that's kind of what I've seen and what my company has seen as one of the best policies in all the states that we operate in. So Arizona, I think first and foremost in the process, really delved into how to identify a distress system. So they gave just a bunch of characteristics of what a distress system is, right? And I think that the biggest pro to doing something like that is it really allows for the arguing in an acquisition transfer of, well, this system isn't that distressed, or, it's in compliance 90% of the time, which means that it's fine. It really takes the guesswork out of it, and it lets companies know going in like, hey, this matches all the criteria of a distress system. This is, objectively from the point of view of the commission, distressed. So let's talk now about how to expedite it, right? So I'd say that's the primary driver behind why that's such a good policy. And the rest of it is, if it's a distressed system, now let's talk about how to get them out of the industry, right? They have something called a deferred debit, which is kind of like an acquisition adjustment, but slightly different. Basically, it is meant to bridge the gap between purchase price and net book value for distressed systems specifically. And it allows a company to close on the system, to have a plan in place to bring it out of that distressed kind of state of being. And in a rate case, then it allows the company to show like, hey, we did X, Y, and Z improvement. We brought it into full-time compliance. We did what the commission and the ADEQ in Arizona is what they're called. The ADEQ told us to bring it into compliance. Now let's kind of talk about bridging the gap, and let's talk about, whether or not the company deserves to be able to bridge the gap. So that's kind of what I've seen as being really helpful to incentivize companies.
And following up about that, so I'll first say that we're not going to delve into any definitions or discussion about what would constitute a distressed or troubled system, because those are some of the arguments that are being made in pending docket, so that we will stay away from questions about such definitions. But has Redbird found that these incentives that you've been talking about, have they been effective in allowing Redbird or other utilities to acquire these smaller troubled systems?
It has. I believe that we're in Arizona up to, gosh, this is a little bit of a guess, but I think about 30 systems that we've transferred. So in our foray into Arizona, we filed 16 acquisition applications, which the staff was not very happy about. I think that's kind of our go-to. But all of those were kind of transferred through. They were all identified as distressed, and it really put an incentive to the staff and an incentive to the commission to allow Redbird to come in and start making those changes. And I will note as well that Florida as well, we just finished up a year-long series of workshops in Florida that also put a definition to a distress system. And so we've seen other states actually see the benefits of Arizona and kind of adopt their mentality or their way of doing things.
Okay. And that's helpful. I think that there may be some disagreement with the public staff about whether a definition is appropriate or not. So we'll leave that at that. But then on your slide dealing with grouping based upon similar cost of service or similar characteristics, and you talked about the tiered approach. Have you seen, I thought that was interesting, but have you seen that I'm not talking about the purchased water systems or wastewater systems, but have you seen that like a tiered 1 or tiered 2 grouping that some of the systems might migrate between 1 and 2, and how would that work?
Yeah, we have. So I'll use just as a really easy example. There is a facultative lagoon that is in distress, right? Some of their permit limits changed or were modified, and we have to include some additional treatment at the tail end, right? So their treatment technology upgrades to being a tier 2. We generally do that in a formula rate plan or the next rate case. It doesn't happen automatically because obviously when changing rates, especially increasing them, doing that automatically is not good for the customer. So generally what happens is in the next rate case or the next formula rate plan filing, we will make an actual filing that calls that out specifically, right? System A needed this extra technology. We have the proof that it was necessary and prudent, and so we asked the commission to migrate them into that higher cost tier.
And then on your timing and efficiency information, you talk about how in other states that they've been able to combine several acquisitions into a single application. Can you provide some more information about how that is done in other states and whether you have found it, in your opinion, to be effective in encouraging transfers or acquisitions?
Yeah, definitely. Whenever I first started at CSWR about 4 or 5 years ago, that's the only kind of acquisition application I knew of was you could file 4 or 5 in one single docket for one kind of expedited transfer, as well, I'll call it. It definitely provides its challenges in terms of data requests and providing information, but it is streamlined. There is a kind of a general statutory timeline for those, so it does. For better or worse, force the commission staff and the company to work really closely to answer all the questions and get the reports and recommendations out in time. I will say one state that, not to mention Arizona again, but Arizona is really good as well. So in Arizona, the acquisition applications are treated as separate applications. So their own timelines, their own DRs, their own docket numbers, which is helpful. But if we file, let's say, 10 within the same month or within the same 2 months, then they consolidate the procedural schedule, which really helps out the company. And I think it really helps out the commission there as well. So rather than having 10 separate hearings 2 days apart, there's one hearing. A lot of the issues are similar, right? A lot of the arguments being made are similar. So they're able to consolidate that procedural schedule into one hearing, answer all the questions they have. It's a little bit of a process reading the docket numbers and transferring from one to another. But overall, I think it's really helpful in Arizona.
And I understand that the efficiencies would be gained for the utilities with combined applications. I think the public staff would say that we have statutory deadlines for issuing decisions, which puts some time pressure on the public staff, and that by combining applications, that would be an administrative difficulty or burden for the public staff. Do you have any response to the public staff's concern?
Yeah, I would say that especially in states, there are some states that are very formal with working with public staff and commission staff. In states like this, where we're allowed to have conversations with public staff, I think that it's in everyone's best interest to do that, right? So if we have to, do a motion for extension on the first 9 we filed and say the statutory timeline is based on that last one to give them as much time as possible, I think that at least for myself, I would be more willing to do that than have 10 separate hearings, right? So I think it's really just about communication and efficiency in that sense. And, based on that example, that would give public staff and the commission more time on some of those earlier filed acquisitions. So hopefully that would solve that issue. Maybe I'm misinterpreting the question, but that's one example that I would see. But really just communication. I think that streamlining these is beneficial for everyone. Local public hearings, the actual hearings themselves, the testimony, et cetera. I think that there's a lot that goes into all of this, and however we can make it easier for all parties, we'd be willing to have those conversations and extend the time frame just a little bit to accommodate that.
That might be a topic for further discussion in the next stakeholder meetings. And then again, on timing and efficiency, one of the Redbird's recommendations is about waiving items that might not be readily available at the time of the transfer, like easement or ownership information. One of the problems that we've seen in North Carolina previously is when the easement or ownership information is not established or provided at the time of acquisition or transfer or CPCN, difficulties could really arise after the fact when that information is, when we discover that there's issues with demonstrating ownership. Can you respond to that? Because by providing all of the information that you need at the outset prevents problems in the long run that may be more difficult to solve after the fact.
Yeah, I definitely understand and agree with that point. I think what we've seen and what I've seen in other jurisdictions is the cost that goes into trying to solve issues that might not ever come up. It's a balancing act, right? I mean, one of the things that we do in every state that we operate in is title work prior to closing. So we do title work on the treatment plant, on access roads, on all kinds of stuff to make sure there are no liens against the facility and we have the access we need. And lift stations, it was actually a decision at the corporate level to take lift stations out of that title search process. It's very expensive, and what we've seen is I can't think of a single issue in another jurisdiction that has come up with the lift stations off the top of my head. So that's not a great answer, obviously, because there are problems that come up and there are issues that you have to tackle. And so I guess my weak answer to that question is in other jurisdictions, we try and tackle those problems when it comes up. Prescriptive easements is a thing that we utilize in other places. But we have seen that it is cost beneficial to the customer and for the efficiency that we haven't done that kind of across our footprint in other states.
And then my last question deals with rate base. And again, this is at a high level kind of policy perspective and not about any particular application. But what I'm interested in is by deferring a determination about rate base from the transfer proceeding to the first general rate case, and not about any particular docket, but how does that incentivize Redbird or another utility to acquire some of these existing systems in North Carolina? What tangible benefit is there to moving forward if the rate base is establishment of the rate base is postponed until the rate case?
Yeah, I'll give an example from another jurisdiction to try and not keep it super high level. Tennessee is a state that allows us to defer the setting of rate base until the time of the company's first rate case. And what we've seen there, and this is found in all of our settlement statements as well, is 6 months prior to a rate case, Limestone, which is the Tennessee affiliate, has to file with the commission any kind of accounting record changes that it attempts to make from the purchase accounting. So we do this initial purchase accounting with all the assets that we know are there, and we have what I'll call a pseudo net book value that is established at the time of acquisition. What we've found in Tennessee with some of these troubled owners is we get in and we realize that this pump they said hasn't been fixed in 20 years. It's actually a brand new pump, and they expensed it. They haven't been through a rate case yet, so ratepayers have never seen any kind of rate increase or cost change from the fact that this brand new pump was put in. But the seller just didn't know that they were supposed to put it into rate base, right? They didn't know how they were supposed to do the accounting treatment of a brand new asset or the replacement of an asset. So once we go in and we see like, hey, the seller said this pump was 20 years old, it actually looks way newer, then we're allowed to have conversations with the seller and, get the backup documentation, the supporting documentation. And in that state in particular, 6 months prior to a rate case, we say, hey, commission, here's what we found after owning and operating the system for a year or so. Here's the changes we would like to make. Does this make sense to you? Does this make sense to the staff? If so, then great. We're gonna seek to establish this rate base at the time of our first rate case. So I think the incentive is with troubled systems and distressed systems and systems that don't have a whole lot of accounting acumen, is what I'll call it. They just did things wrong, and it gives us an opportunity to shore up the accounting records and to establish, what we believe is the true rate base, the true net book value of a given facility.
Thank you. That's all the questions I have, so I'll look to the commissioners. Commissioner McKissick.
First, let me thank you for being here today and appreciate the comments you've shared. I just want to get a little bit better sense in terms of that term distress systems. I've seen it characterized perhaps by one company in a way that's different than what public staff might say. Has there been any consensus reached about what a distress system might be? So that's my first part of the question. And then secondly, you pinpointed Arizona in terms of what they're doing with distress systems. And I'm trying to get some idea of what that timeline looks like there when you talk about expediting the process, to compare that and contrast it to what would otherwise be the case, say, in Arizona, and how that might compare or contrast to North Carolina.
Yeah, definitely. I'll speak at a really high level about the definition of distress system. So basically the policy that I kind of reference in the slides, and I apologize, I should have given a reference. I'll do that in the future. It's a really, really long policy, and it just lists all the characteristics. So I'll don't know how, so I'll just say in Arizona, one of the things that differs from the Florida definition is rate base of zero, right, for a non-contributed system. So in Arizona, they see that a rate base of zero is a characteristic of a utility that hasn't invested or reinvested at all, right? And if you've been around for 20 years and you have reinvested $0, that's bad, right? That has real risks to the customer. So I guess what I'll say again at the highest level is the policy in Arizona lists just a bunch of characteristics that allows the commission to say, okay, system A is 8 out of these 10. We think that 80% means it's distressed, right? Or if it's 2 out of 10, maybe that warrants further discussion. It depends on the 2. Is the 2 that it had a catastrophic failure in the last year? Maybe that's distressed. Is the 2 that they haven't come in for a rate case in 10 years? Maybe that's not so much. So I'll say defining and listing specific characteristics gives a level of assuredness to a company that that everyone can agree this is distressed, right? And in terms of the timeline, recently there was a new timeline enacted on acquisition cases here in North Carolina. It's actually very similar, I think, to what it is in Arizona. There is a shortened time frame if there are environmental violations, similar to here as well. So I would say, it's actually pretty close. In Arizona, it takes about 6 months. I think the statute in North Carolina is 7 or 8 off the top of my head. So it's not different enough to warrant any further discussion, I would say, from my perspective.
Okay, thank you. That's helpful.
Thank you.
Mr. Hughes?
Yeah, good to see you again. How common are purchase systems in the Central Water States portfolio just across the country? And, does it vary by state to state? Are there states that you have a pretty big purchase system footprint?
Yeah, it definitely does vary state to state. There are some states where we have no purchase water systems, some where we only have one. I would say our largest utility operating company that has that purchase water, I'd say it's 2, is Louisiana and Texas. We have quite a few there.
So with that being the case, how do you deal with uniform water in those places? Has it been any different than in areas where there isn't an abundance of purchase systems?
Yeah, so it's really about that tier or district breakdown, right? So what happens, I'll use Louisiana as an example. We set a single revenue requirement and then we split that cost based on the tiers. So purchased water and purchased wastewater actually are all in tier 3. There's no other kind of treatment in tier 3. They have their own kind of breakout. And we take a much smaller percentage of the overall cost of service and apply it to those customers because our operators there have to respond to distribution system issues, leaks and stuff, but no treatment, no, daily site visit of the plant. So they just get a much smaller percentage cost of service than the rest of them. And then the entirety of that pass through, usually adjusted for water loss. We do, in certain jurisdictions, we're required to file annually a true up of the pass-through charge. And in some jurisdictions, we only file it when the supplier changes their rates. So it definitely does vary quite a bit. I would say that the annual true up is really helpful for us because it forces us to take a look at things like water loss and really kind of hone in on that true pass-through that goes to the customers.
Thank you. Just to clarify, when you say the pass-through is run straight through, is it run through on a system level or on a tier level? Do you group all the purchase systems in one tier?
Yeah, that's a great question. So the percentage of the cost of service is kind of what I'll call our flat charge to those, say we have 5 pass-through in Louisiana. They get a certain percentage of the overall cost of service as a flat fee, and then the pass-through is on a supplier by supplier basis. So if one is in northern Louisiana and it's supplied by, supplier A, they get a pass-through that's specifically based on what supplier A charges us. And then in southern Louisiana, they're supplied by supplier B. Their pass-through portion is specifically based on what supplier B charges us. And that's what's helpful about those annual true-ups is it forces us to look at all those systems, see if the supplier changed their rates without, notifying, et cetera, and really kind of, like I said, hone in on the specific cost of service at those specific pass-through facilities.
Okay. Thanks for that. It's just following up a little bit on Commissioner Tucker's question, not for you, but just his early question, and also Commissioner Kemmeright's. From a business standpoint, I would think, first off, conformity or consistency would be important. But even more than that, revenue security and cash flow security would be essential. So I'm just trying to figure out when you go in and make a business decision, not getting into any details, but just in general, not having confidence about what the rate base is and what the cash flow is going to be in the future. How do you navigate that? And how do you, I would just think that would be really difficult. And how do you navigate? does the risk get rolled into the purchase price, or, because obviously you'd be carrying a huge amount of risk.
Yeah, I think that's a great question. I think that, I'll use Tennessee as the example again, where we are deferring the rate base setting into a future rate case. So I would say a couple of things there. One, there is a risk, right? And the fact that the company and our executives who are a little above my head are willing to bear that risk, I think is good for the customers, right? The customers don't bear any of that risk. It's all the company, which I think is good for them in the long term. And then I think, and this is just from solely my perspective, if we were to set net book value or rate base in Tennessee at the time of acquisition, let's say it is $50,000 and our purchase price is $100,000, right? That if we choose to move forward, then that's a 50,000 air ball. If we choose to defer, that 50,000 air ball is still there. It's still a risk. It's just we now have an opportunity to prove to the commission that it might be more like a 25,000 air ball, right? So whether it's established at the time of transfer, and we know for a fact there's a 50,000 air ball, or we have an opportunity to make an argument or make our case for a little bit more net book value or a little bit more rate base, I think that is just beneficial to us, right? We know that's there. We know about the risk, but we have an opportunity to make a real case for what we believe is the true net book value or rate base after we are in there and operating and understand the system and understand it a little bit better. So from my perspective, that time frame, the customers bear no risk at all. It's just the company, and it gives us an opportunity to learn more and prove our point a little bit more. So that's kind of what I've seen. Sorry if that's a little roundabout way of answering your question, but that's kind of my
That's fine.
perspective.
Thanks for the, a new idea that comes to mind whenever I hear the word airball. The last question again relates a little bit to the negotiation that goes on, because obviously this is a huge issue for everybody involved. Have you found states where, because of some sort of state level policy, sellers are more prone to come to utilities like yours with just a more reasonable price, as opposed to a state where the seller kind of can just feel like, well, we can keep going in the way we're doing and nobody's going to come after us? I think it gets sort of how much does a seller want to get out of business, and how much do they feel like somebody's watching them?
Yeah, I mean, that's a great question. I could talk about this for a long time, but I'll keep it short, I promise. One of the things that I've seen in Missouri, which is the state we've operated in the longest, is the Missouri DNR, the Department of Natural Resources. Before they had I'll say partner, because that's what I see us as. Before they had a partner who they knew would come in and take over these extremely distressed systems, they didn't have a means of enforcing environmental violations and environmental quality concerns, right? Unfortunately, the reality of the situation a lot of the time is that you would rather have someone there who might not have the technical and managerial qualifications, but is at least doing a little bit of a job than no one. And what I've seen is a lot of the time environmental regulators, when they try and put the pressure on a seller, the seller will say, you know what, drop the keys, walk away. I'm not doing this anymore because I can't keep up with it. And so what I've seen in my experience is once the environmental regulators have someone to point these systems to and say like, hey, you're in way over your head, you're about to rack up all these fines, there's a buyer who's willing to let you out. And if not, then we're going to really put the pressure on you and see this thing through. That is the situation where we're allowed to really get $1 purchase prices, because our business developers are all trained and I'll start every negotiation with $1 because we operate with these distressed systems that have a lack of accounting acumen and a lack of managerial and technical capabilities. We think that $1 is the right place to start pretty much every single time. and it goes up from there because sellers aren't willing to get rid of, you know, an income stream. But I found that if there's significant pressure put on environmental regulators, that generally tends to put some sense into the seller's heads about, yeah, this is an income stream, but if I don't get rid of it, then it's a huge liability.
That's really helpful. I don't have any further questions. Thanks.
Commissioner Brawley.
Thank you, Commissioner. I want to address two things that you were suggesting out of your own experience that this commission might consider. One, you were discussing a regulatory asset, and this is where you are deferring rate increases to a uniform rate over a number of years, accruing that discount in something you called a regulatory asset on which you would earn a rate of return. Are you also amortizing this regulatory asset over a number of years, and if so, how many?
Yes, sir. I am not an accountant, so I apologize if I get this wrong. I believe the amortization period is different state by state. I believe in one of our jurisdictions, it's over 20 years, and a bit shorter in one of the others. But I believe it's 20 years is the one that comes to mind. But yes, it is amortized. It is, you know, taken down so that we're not kind of earning on a forever asset.
Okay. Thank you, sir. A second phrase you used in dealing with some of the deliberations and a way that y'all sometimes approach, and I took the inference that you were asking us to look at a similar approach. You used the phrase, the cost of trying to solve problems that might not come up. And I wanted to explore this with you further because you also made reference to risk, and that by not quantifying risk at purchase time and the ability to recognize that risk later in a rate case. But I also wondered, isn't that transferring risk onto ratepayers as a whole, and to some extent, maybe even on this commission, to act without complete information? And while I recognize that in some financial transactions, this might be a loss, when I was listening to this, I will tell you what it reminded me of something I studied recently. On SS Titanic, they had the number of lifeboats that were required by the British Board of Trade, which was only sufficient for half the number of passengers that the ship would carry. And that was a problem that, since the ship couldn't sink, they didn't feel they needed to address. Now, while I am hopeful that we are not going to be in any situations that have the downside of SS Titanic, I would caution you, sir, we will not tend to be willing to ignore potential risk without making a great deal of effort to quantify it, and in some cases, asking you to do the same. Thank you.
I don't think that was a question for you, Mr. Silas.
No, I think it was a great point. I'll say that. I think that's a great point. Thank you, Commissioner.
Commissioner Tucker.
Thank you. Having only owned a 30-foot boat, I can't equate that to a Titanic, but and hopefully these questions will not even border on concern of what's on the docket. And if it is, again, please preempt me. You know, we, if I recall correctly, in my county commission days, we had a considerable amount of complaints on the independent sewer systems. We also found, and I think state law allows it, and correct me if I'm wrong, Madam Chair, that the state permits these systems. And so when they're become distressed, the customers call the politician, or they'll call the county. And the county's position is, not my job, we didn't permit it. So that allows for these systems to kind of continue to run without any supervision at all within the state. And they are, you know, pretty much dilapidated by the time you guys take them over with your dollar purchase price. In other states, how are they managed before they get into this precarious distress situation, which in turn requires you to come in at $1, which in turn requires you to make an investment, which in turn requires you to increase the rates to recoup your investment? What's the situation you talk about? You know, your love affair with Arizona and Texas. Geographically, those states are much different from here. But in my county, we have the largest county water sewer system in the state. And we are maxed out in capacity because we're a bedroom community to a large city. And so we're getting more and more applications for independent water and sewer applications within the state for my county. What other management mechanisms do Arizona or Texas or wherever you've worked have? How is that handled? Does the county inspect? Does the state inspect? By the time here, the state gets around inspecting it, it's a fire drill big time. So if you could expound on that, it'd be helpful.
Yeah, definitely. I think I'll answer at a little bit of a high level first, which is that the reason why Texas and Arizona have these policies that that I am promoting so much is because they're experiencing the exact same issues that you guys are here in North Carolina. Really, really distressed systems, really, really dilapidated systems that were ignored for a long time. I will say that there are, and I'm not 100% clear on the North Carolina Department of Environmental Quality's policies, but there are some states that allow sellers to do their own sampling and their own testing.
That's right.
And that I have found in my personal experience to be a very, very bad idea. You have sellers who don't want to own up to the fact that their systems are not operating at the way they need to be. And so I will also say that in the states where that's not the case, the environmental agencies have a lot of personnel. And I don't know if that's the case here in North Carolina. It really varies state by state. I have seen that funding of the environmental agency and ensuring that the environmental agencies have the personnel needed to do the testing and to do these site visits really, really helps stuff like that. I will also note that, and this is getting into probably some stuff that I am very not versed on. There are a few states that we operate in where the acquisition conditions is what I call them, the conditions to transfer, really start to talk about environmental concerns and engineering fixes, right? You have to fix this within this amount of time. Instead of relying on the environmental agency to regulate and to enforce, the commissions in some of those states have made it a condition of closing to really focus on stuff like that, which I don't know the logistics behind that, but it seems to be helpful in those states.
So if I'm gleaning from what you're saying, more inspection or reporting from the state rather than allowing the owner to do his own testing kind of preempts the fact that the system doesn't become so dilapidated over time. You know, that's what I'm getting at, because I mean, they're in a mess by the time it gets to the government level, state level, county level, political level. It gets to be an issue. So you're saying that more testing by independent sources versus the owner doing the testing and submitting that data, right?
Yes, sir, Commissioner. I think that the objectivity of knowing that, you know, your system is out of compliance and the understanding that that data is public and people see it and everyone knows about it tends to prompt action a little bit more than some situations where they can sweep it under the rug.
Very well. Thank you. Thank you, Madam Chair.
So, Mr. Salas, that comes to the end of questions for you. Thank you very much for your presentation and for answering the questions.
Thank you so much. I appreciate the opportunity, everyone.
And with that, I think that Carolina Water is up next.
Yep. While Mr. Schellinger is approaching the bench, I wanted to also recognize Tony Consul and Zach Payne, who are here from Carolina Water to provide any support that they can. Thank you.
Good afternoon. Thank you for having me here. My name is Matthew Schellinger, Director of Finance for Carolina Water Service. I'm going to discuss a lot of, I think, similar things what you've already heard, both from the stakeholder meeting as well as from Central States. Hopefully with a little more nuance, so it's not just a repeat for you. I think it's important to take a step back and remember from a strategic perspective, really, why we're here, why we're having these discussions, at least from Carolina Water's perspective, right? And that's that we're a long-term player in the state. We've been here for 40 years. We're going to be here going forward. And we see uniform rates and uniform revenue requirements as that ultimate tool in the toolbox. And I think I've used this term before, maybe in a prior discussion, to take the top side of rates down, right? Which really gets back to the core of rate affordability. Every system is going to need work. They may need it now. They may need it in a couple of years. They're going to need it eventually. And if you wait until that system needs work before they find their way into a uniform rate paradigm, all you ever have is upward rate pressure on those rates. So you need a wide base of customers, a wide base of systems that have varying time points when they're going to need that work so that you're really bringing down that top end. And second point I have here on this slide, the strategic outlook here, is large utilities in Carolina Water specifically, we provide a lot of really big benefits over a lot of the smaller utilities that go beyond just the ability to walk in and start implementing that capital, right? We've got the billing, we've got the customer service, we have the IT, we're able to react to changing environmental and regulatory frameworks in a much better way than these smaller utilities can. And there is a real intrinsic value there to those customers on day one of ownership, even before, you know, that first pipe in the ground is replaced. Like, there's benefits there right from the beginning, and I don't think those can be understated. This slide here is just a repeat from last discussion, but I think it once again finds its way and helps ground why I think we're here today. I found a couple of notable, what I would call notable NARUC resolutions that I think really go back to some ideas that NARUC has identified as best practices. And they once again get back to this idea that single tariff pricing is a mechanism that can be used to spread the capital costs over a larger base of customers. This is a more recent resolution, but really is kind of a reiteration there of that same best practice. And really key here is it's reduce rate case expense and offer rate increase mitigation options driven by the economies of scale that would otherwise be unavailable. All right, topic one. Where Carolina Water thinks that really the only defining characteristic in rates is, are they a water customer or are they a sewer customer? I'm not going to go through and read through this, but I do want to maybe drive home what I think is a distinction between both the public staff's perspective as well as Central State's perspective. And that's that if you have tiering, you naturally still have your peak. You still have your highest, you still have your most unaffordable rate. You're not truly getting that benefit of a true uniform rate driving down the peak, right? Because I think from our perspective, the rate affordability question really comes at what's that highest amount that the customer is paying, right? And if you have a bunch of rates that are at, say, low tier, they're not helping shave that top rate, shave that peak down for the rest of the customers. And having a tiering that is potentially based on higher cost treatment, or do they have PFAS mitigation items, those things, having that separation, that tiering is only going to drive that peak even higher. And so I think that's one of the areas maybe where we differ, and a true uniform rate helps cut that peak off. Let's see. Topic 2, the incorporation of transport systems into the multi-year rate plan. I think it makes sense. I think as if you bring them in on a uniform perspective, you bring them in on uniform rates, which are probably a WISP rate at that period of time, that it makes sense that they just naturally find their way into the WISP. I think where there's some pain points really comes on the performance metric reporting on the back end, right? Because you may have a capital list that's based on capital that doesn't include the transfer systems or other performance metrics along those lines. But really that's on some level just reporting mechanisms. There's way to get around reporting mechanisms. There's way to be very transparent with the commission and say, here's the original WISP, here's the layered on transfers, here's what the world looks like. There's ways to get through those. And I wouldn't want reporting to hamper, I think, some of all the other benefits here and keep them out of the WISP until, every 3 years or 4 years when they roll in. Let's see. Rate affordability. I think we've discussed this a little bit before. It really should be broad programs, like broad customer assistance programs, not system specific. You don't want it to be too narrow of a benefit there. Otherwise, you might be leaving people out that really could benefit from some of those customer assistance tools. The other thing I think that would be a benefit, and I'm not sure the best way to get it across, is I think there are a lot of customer assistance tools in the state at county levels, at municipal levels, at just large entity levels. And a big piece that I see as a problem here, or an opportunity really, is really more of the noticing. It's the how do you actually get all of these tools that are there into the customer's hands? And that's really, I think, more of an easier direction to at least start with, right? How do you make sure that the customers know what's available in their county, what's available in their municipality, what's available near them from those entities? And I'm not sure that that part of the question's as well answered. And then to the extent that a CAP is, customer assistance program is implemented, it should be easy to access and apply for, broadly communicated, and simple and efficient to administer. Topic 4, let's see. Whether a system that has a cost of service less than the uniform rates of service should be included in uniform rates at the time of transfer. So as discussed in the stakeholder, we really read this in a very narrow transfer acquisition perspective, not necessarily like the new developer CBCN that comes in, because I think there's not a lot of disagreement on, say, a new developer CBCN coming in at the uniform rate. So to the extent that they are lower, we think they should still just come in at uniform rate. And then in the next multi-year rate plan, those revenue requirements get combined and the rates get adjusted on that full outlook at that point in time. And really, the primary goal there is that if you're constantly waiting until a system's cost of service gets high enough to where you think it should go into a uniform rate, then you've removed all of that benefit for that period of time up until when their cost of service might be high enough that there's at some level the public staff will say, okay, we're close enough they can roll in, right? But if you roll them in from the beginning, they start getting that benefit to the whole rate group from the beginning. Should the commission consider appropriate ongoing policy use uniform rates? And once again, yes, I believe that they should. Mechanisms that facilitate efficient transfer of small water and wastewater utilities. From my perspective, and we've recently finished up several acquisitions before you, the full cost of service support and going through that whole discussion about, well, where are their rates right at this point in time, it takes a lot of administrative time. It's an incredible amount of discovery. It's, I'm sure, just as much time on the public staff's front going through all of those weeds and coming to that that determination. And ultimately, if uniform rates is the policy, we can eliminate a lot of that burden, I think. The other side of that burden, and this probably really tracks straight into topic 7, has to do with the setting of rate base. Because it's once again a very timely, or it's very hard to justify the rate base for some of these systems on some level. In a recent acquisition, I think it's closed now, so I can discuss it. I sat there for days going through 3 years of invoices because, to Mr. Silas's point, the utility just expenses everything. They don't know that they need to go and capitalize a pump or capitalize these main replacements. I sat there for 3 years, or going through 3 years of invoicing to say, look, if this were our system, we would have capitalized this, and we would have capitalized this, and we would have capitalized this, and presenting all of that information, all that discovery to public staff in order to justify a rate base that ultimately was where the seller wanted to exit, right? Because that's the thing. We all go in for $1, but the sellers believe there's value to their assets and there's value to their income, and they're not selling to anybody for the $1. So getting to that rate base number is, I think, it's difficult, it's timely, or time consuming. But we do think it also needs to be established at the transfer application point. And this is maybe a area where Carolina Water disagrees with Mr. Silas and Central States. If a rate-based determination is made that is lower than the purchase price, we need to know about that. We need to know about that right up front, because it really could change the dynamics or the math on if it makes sense to continue with that acquisition. So. Those are my key takeaways, and hopefully I didn't repeat too much of what we've already heard this afternoon.
Thank you for the presentation. I have a few questions to begin with. Starting on page 6 about topic 1, and this is for clarification. You talk about how the lack of metered or flow data might limit the consolidation of rates. And can you explain about the constructs for the metered and unmetered tariffs that you talk about in your topic 1 that might provide better alignment for consolidation of rates?
Sure. So I think the way that we do it in current rate cases is probably the best way to do that going forward. So if you have metered sewer and unmetered sewer or flat rate sewer, that right now the way the rate making is done is we say, okay, an average customer uses, say, 3,700 gallons a month. We can impute from the base charge and 3,700 gallons of usage that a per ERC or per SFE customer is really, the math is that simple. It's, let's pretend that flat rate uses that same 3,700 gallons a month, and to just kind of impute what a flat rate customer would be at that level.
Okay, so that would be no impediment toward consolidation of rates from
I
your
don't think
perspective?
so, no.
Okay. And then moving on to topic number 5, you talk about how uniform rates is the preferential way, in your view, unless there's extenuating circumstances. And you talked about your response to Redbird's proposal about having some tiering type of system, which to me, the tiering system is similar to an idea of, at a more extreme circumstance, of standalone rates, of having different types of rates. But you do say that there might be extenuating circumstances that would warrant standalone rates or, possibly a tiering among those different types of rates. Can you talk about when you think that, what those types of extenuating circumstances might be?
I think the first one that comes to mind really is a rate shock question, and it's maybe more timing versus, how long, at what level we want them to get there. So how long does it take to get them there? So I would say the first extenuating circumstance really should be rate shock. But still the ultimate goal to get them there. I think another extenuating circumstance, I think I could talk about this because it's closed docket with our Mountain Air acquisition. There's kind of some like extra stuff in there, if you will, and that'd be like the EO recovery of an under recovered balance for the EO system, or different treatment of, say, purchase price as a rider or something like that. So those are the kinds of things I would say would be extenuating circumstances, but they wouldn't necessarily preclude those systems finding their way into a uniform rate. And some of the ways you could get around that are, I think, exactly what is done in that docket, which is something like a surcharge or a rider. So they could still be fully uniform, but then if there's something special about them, you could handle that through a surcharge.
Okay. And then moving on to your topic 6, which is about ways that we can facilitate transfers of these smaller or troubled systems. On that topic, you suggested that that there should be perhaps some sort of waiver of what you called certain details for non-viable systems. And can you tell us what you mean by the certain details? What do you think that the commission should be waiving to allow these transfers?
I think probably a lot of, once again, back to the cost of service, a lot of the financial information, the financial addendum. The reality is a lot of these smaller systems, they're not going to have a material impact to Carolina Water Services revenue requirement as a whole, right? A couple $100,000 of revenue on many millions of dollars of revenue as a percentage is not going to materially change the nature of the service provided or the financial viability of the company or any of that. So I think in the contiguous extension applications, there's a section that says, like, if this contiguous extension is to serve a nominal number of customers, you can ignore pages like 4, 5, and 6. And I'm sure I'm getting the pages wrong there, but there is almost like this opt-out in the contiguous extension that says, maybe this isn't significant enough to matter. I'm not sure what nominal number of customers is yet. We haven't quite found that exact number yet, but there is some level where it's not going to financially impact the utility to need to get into that level of weeds. So I would say that those would be the kinds of items that I would think of.
Okay. And I think you referred to the cost of service information as being time consuming and administratively burdensome to be determining that at the time of transfer. Public staff believes that information is important at the time of transfer. Are there other ways that the information could be provided to the public staff and then at the commission and determined without it being, time consuming and so difficult from an administrative practice? Is there an alternative that you have?
I'm not sure there's an alternative. I think there's maybe some middle grounds. For instance, in one of our cases we just wrapped up for the Achota acquisition, the Water Resource Management's annual report had them significantly higher expenses and losing money every year, but we still did this full workup of what would their costs look like if they're a CWSNC customer from the ground up, in order to try to justify, some level of cost of service. So, utilizing the prior annual reports, not sure that's the best answer because I mean, and I think we demonstrated we're going to be able to walk in and provide the service for less maybe than he was, at least from an expense perspective there. The other, I think the other side of it is just the level of detail that is reviewed, right? Needing to review hundreds of Duke Energy electric invoices is only so valuable, right? So on some level, it's a little bit of how much does public staff need to review and sample in order to actually get comfortable? And if one of those $100 Duke invoices is wrong, where's the actual benefit there for all of that work and all of that sampling and all of that administrative burden? And I don't know exactly where that line is, but that's part of the administrative burdensomeness is getting that right level of review and that right level of sampling. So I'd stop there.
Okay. That's helpful, but you also talk about some incentives that could be provided to encourage these transfers of the small troubled systems. And I think you specifically mentioned ROE adders and post in-service return. So I've got two questions about that. What about how would those incentives would increase cost to customers? And so what benefit would, when you're weighing cost and benefit, would that provide to the customers that are being transferred and the existing customers? And then are you operating in other states that actually allow these ROE adders and post in-service return?
I'm not very familiar which other states may have the ROE adders. I'm vaguely familiar with the post in-service return, and I believe it's mostly from an example that I've heard about here in North Carolina, actually, where the docket was left open for a period of time in order to finish some capital improvements in the near term. I'd say that's helpful, but it's maybe doesn't actually fix the problem, right? Because if it takes you say a year to deploy the capital, do you really want to leave the docket open for a year? What is near-term capital? And should we not have uniform rates, or as soon as I finish that capital, should I be knocking on the door for a rate case that day? I mean, that's not administratively beneficial for anybody either. So I don't really know where that middle ground is. The other thing is you could set rates as in an MYRP effectively for those transfers. We're going to install this capital over the next 3 years. Let's set rates based on that capital we are going to install over the next 3 years. That could be one way to kind of get around it or mitigate it without needing to leave the docket open in that kind of example.
And then I'm going to finish up in two more questions and then turn it over to the other commissioners. But topic 7, in your presentation, you stated that about establishing the rate base at the time of transfer or at the first general rate case. And in your presentation, you said the written presentation, you stated that it potentially should be at the option of the utility. But my understanding from what you're saying today is that Carolina Water advocates that it's appropriate to determine the rate base at the time of transfer as opposed to the first general rate case. Am I understanding your position correctly?
I think it should be at the option, but I'll say that unless there is one of these kind of extenuating circumstances, the option that we would choose is we would like it set at that transfer proceeding for each of them. So I think saying there's no option would preclude you needing to make these decisions based on some of these other extenuating circumstances. So there should be some leniency there, but from our perspective, vast majority of the time, we would be requesting it be made at the time of the transfer proceeding.
Okay. And last question about how to encourage these transfers. And one of the ideas is combining applications of systems into a single application. Is that something that you think is appropriate and would encourage transfers? And are you seeing it in any other states?
I'm not familiar with it in any other states. I would say from maybe a general perspective, it could be beneficial, but I'm going to flip a little bit from my own perspective and just looking at our own timeline. The acquisitions don't come in a pile of 5 or a pile of 10. It's one and then a delay and then one, then a delay. So I don't see that it would have helped, say, any of our more recent transfer proceedings having, a pile of acquisitions together. That just would not have applied to us.
Okay. Thank you. So I'll check to see if the commissioners have any questions. Commissioner McKissick?
You spoke about customer assistance programs. And obviously there's a consensus that this issue of affordability needs to be addressed. Is there anything that you've seen in other jurisdictions that you could say could serve as a model or as a benchmark in terms of best practices or models to address the variety of issues that are faced by different utilities, particularly when take into account the size of these different utilities, even when they're acquired? So, I mean, what thoughts do you have other than just a consensus among those that are involved with water systems and acquisition systems that the issue of affordability needs to be addressed in a comprehensive way?
I don't have a lot of experience, and maybe in somehow other states are handling it. I know some states have some, say, low income rates available to them. I know in other states that would cause large discriminatory rates issues. So it's kind of based on how the statutes are written in any given state for that sort of thing. I apologize. I don't have a lot of
That's fair. That's fair. I guess, since it was one of the things that I guess all of the stakeholders agreed upon, I guess wonder, other than there being a consensus, if anything emerged about ideas or best practices or approaches other than what was generally touched upon during this kind of the stakeholder briefing component of the meeting today.
I can tell you I'll do some research on it before the next meeting.
That'd be great. Thank you, sir.
Thank you.
Commissioner Tucker?
Just one quick question. Since all 3 companies pretty much are singing from the same song sheet as I've read, and you've done all this work, have you quantified the benefit to the company in terms of overhead cost, administrative cost, et cetera, that you would save if the commission chose down the road, after much discussion, to have uniform rates?
I've not quantified a benefit to the company, no. I'm not sure. There is a ton of benefits to the company here specifically, right? The company sees the rate pressures coming. We see that as a very real challenge. And this is one of the tools that help that. That doesn't put more money in the company's pocket by any means, but it helps those customers at the higher end.
Okay, so you got 85 employees for the state of North Carolina, and you don't have to file or do as much reporting to public staff commission. That would reduce overhead and numbers of people that's required to balance out what's required from public staff in the commission. There seems to be some reduction there would be for the company. I mean, I'm just point blank and ask you what financial advantage is. All 3 companies are saying the same thing. There's got to be benefit. Your business people, profit is required for you to stay in business. I would have thought you perhaps, or the other companies, would have had some sort of quantified number that you save 10% or 15% in overhead cost simply by going to uniform rates, is kind of where I'm coming from. And then if I can get on the other side of that, perhaps there could be, if there was a savings there could be a rate reduction to the consumer. I'm just asking.
Sure. I don't think you're going to see any real reduction, but I would say that it's going to make that next needed headcount take longer, right? We're not going to need to hire that next regulatory reporting person as soon as we would otherwise. And I think that's really more of where I see the benefit, right? We have an incredible amount of reporting we do already. Even taking a chunk of that reporting away isn't going to reduce a head count, but it might make that next head count not come as quickly. Is that where I would think the main benefit is there from something like that and reducing some of that administrative burden?
Okay, thank you.
Ms. Seifert, I see that you're trying to address the commission.
I am, if I might, and I'm not sure that I ought to be because I know you're here to hear from these other folks, but I do have a comment that I think is relevant to Commissioner Tucker's question here. If there is a reduction in expenses, then that will be captured, and I would invite argument on this, but that will be captured in this process. It'll be captured by the company and then reviewed by this process. And there's another issue that I don't know that we're talking about, but it looms in the room on this, and that is that the companies are concerned for all kinds of reasons about internal efficiency, but they're also very concerned about this tide of rate increases that you know about and that the companies are speaking about and that they see coming. It's a lot of that is code for PFAS and other emerging contaminants, but it's not just that. It's aging systems that were donated but now have to be replaced by the company. It's all that combination of things that are driving rates up. And that is a lot of things, including, these are my words and not the companies, but I'll say not so good for business. It's bad for, it's very concerning for customers to be facing what it seems like might be coming with respect to the rate increases. So the push for efficiency comes from so many reasons inside the company. Thank you.
Okay, I think that comes to the end of the questions, and thank you for your presentation. So I think now we'll move on to presentation from Aqua.
Ruffin Poole and Kim Joyce are presenting.
Good afternoon. My name is Kimberly Joyce. For those that don't know me, I work for Aqua and Essential Utilities. I've been with the company for over 17, 18 years now. I've worked on intimately on every rate case for Aqua North Carolina during that time period, and it's always been a pleasure working with public staff and the commission, so happy to be here today. I am not Shannon Becker. He was here today. He's on a paid time off vacation. So again, he wishes that he was here, and apologize you're not getting them, but please be easy on me because I'm filling in for him. To the left here is my colleague, Ruffin Poole. He's the Director of Development and Regulatory Affairs for Aqua North Carolina. We will try not to repeat what has already been said, and I think we have some initial thoughts and comments, and then we'll run through the questions, and again, but try not to be repetitive of what has already been stated on the record here. Before I forget, I did want to follow up on a question that Commissioner Cameron had from Redbird on certain proceedings, and I think you had asked about Arizona and Texas, and I think we heard the answer on Arizona, but I did in my notes have a discussion on Texas because the Texas Commission, as we speak, is investigating the exact same issues that we are here in North Carolina, and they have a live open docket on implementing a statute called the filed rate doctrine. And the Texas Commission in the state of Texas has many, many small distress systems scattered throughout their state. And they have a policy and they want to encourage the Class A water utilities to purchase those and consolidate those acquisitions where it makes sense. And so the commission, along with industry, worked on legislation called this filed rate doctrine. And it's how you bring in troubled systems into a consolidated rate structure. And the statute actually says that the utility can propose in the application process a current rate that the utility already has. So I just throw that out there. It's really easy to research on the Texas Commission. And I have the docket number here that I wrote down. It's It's docket number 53924. If you have the time, I think you'll hear a lot of similar arguments, and it's the same topic that commission is struggling with. But I just wanted to throw that in there before I forget. Again, high level, before we dive into question 1, and this does, I think, follow up on Commissioner Tucker's question or comment. When I think about North Carolina and the rate cases that we've had before this commission, and we describe the North Carolina regulatory environment to people in the industry, to shareholders, to customers, I describe the regulatory policy of this commission as encouraging consolidation and having single tariff pricing, right? We've lived that, we've done that, and we started that process over 20 years ago, and that'll be my next slide. We get there. One more. And so when we were thinking about preparing and our answers here, to me, the question that the assumption we had about the focus of these proceedings here is not so much whether single tariff pricing is good, a benefit. We've clearly seen the benefits of single tariff pricing for Aqua North Carolina, particularly when before, as we sit here today, we have 5 different revenue requirements. But at one point, there were many, many more boxes on the left-hand side there. And that created a lot of administrative issues, tariff confusion. And over time, we worked to merge and consolidate. So in our world, we call that single tariff pricing, and we have a consolidated rate structure. It might not be one, and we might get there, to the right side of the screen, that's Aqua North Carolina in the future, right? We can get to one water and one wastewater, but that will be our burden to present to the commission at the right time. But that's where we'd like to get to. But again, we think we have single tariff pricing in North Carolina. Can we move some of the tariffs further along? Certainly. But again, that'll be our burden of proof to present to the commission at the right time. But it was really, really important, I believe, to have that mechanism and to continue to have that mechanism, particularly when you look with all the issues that we've had with iron and manganese and certain other secondary water quality issues that we've had over the past decades. Without single tariff pricing, the impact on rates for some of our customers, our systems, I think, are similar to Carolina Water. Lots of small groups of customers, 35 customers, 50 customers. And to put in some of these filters, if we would have had standalone rates for those customers, it would have been cost prohibitive. So just wanted to set the stage on how we think about single tariff pricing. I think our focus here is, if the policy of this commission is to encourage acquisitions, how do we encourage acquisitions at the same time and in correlation with single tariff pricing? I think there's lots of different policies, best practices around the country that we can utilize to meet those goals. The other note that I had before I get into sort of the details, and I did not think this was going to be controversial, but just based on the conversation, the tone, if there's an ask from industry, and I think you hear this a lot, guidance is important. And I think guidance on what types of acquisitions you'd like us to bring before you, ranges of purchase price, what will constitute a distress system, that kind of guidance is helpful for the industry. And I don't think the industry thinks that it's going to be a check the box. You have this and you get that. I don't think that's what we're asking for, but a list of examples, like help our business development teams, help our management teams understand the expectations of public staff and ultimately the commission. As the ultimate goal is to try to consolidate and help customers in the end. So with that, I think I answered question 1. Question 2, I see as a technical question. How can we technically incorporate systems into the WISP multi-year rate plan? my view of this, and I think Aqua North Carolina's view is this, is listen, the multi-year rate plan is new. We don't know what we don't know at this point, so it's a learning process. But I think the answer to the question is, yes, we can technically include new acquisitions in the multi-year rate plan. It's just going to probably take some growing pains and some learnings, but we can technically do it. There's just going to have to be flexibility in the models and how we think about capital investment, and maybe not managing to a particular dollar amount, but there's going to have to be flexibility in doing so. The third question about low-income programs. So we're currently in 9 different states, and we have different varying types of low-income customer assistance programs. I would say on one end range of the spectrum, which is a fairly aggressive program in Pennsylvania, we have a fully customer-funded customer assistance program. It's 100% subsidized by rate-paying customers. And on the other end range of the spectrum, we have much smaller programs, which are funded by our employee base, which are and funded by different types of grants that we apply for. So there's all different mechanisms. I personally believe that I know we look to the statute that talks about discriminatory rate making. I personally believe that there's flexibility in that definition to have funded low-income programs. But that's a policy decision for the commission, and I think we understand that. And the last question before I turn it over to my colleague here, I think, this is the question about, if the policy goal is to encourage consolidation and encourage acquisitions, there's definitely going to be instances where cost of service can either be lower or higher than what I would call like the uniform rate at the time. And there's ways to deal with that. But I think that moving to, and we've talked about it, in the life of the transfer application, setting a rate in that application can be very beneficial. And at the end of the day, it will encourage acquisitions. Because more often than not, the cost of service is going to be lower than what you would call the uniform rate. And that more often than not, that rate is going to reflect lower investment because that owner did not put in the investment that the utility did. So moving that rate up might be unfair for a period of time until that utility invests in the system. But at the same time, if there is a policy to move it to the main division rate or the uniform rate, that's going to encourage acquisitions. So it's not perfect, but it's, again, what your policy goal is. So with that, Ruffin?
Thanks, Kim. We've heard a lot of this, and I'll just touch on a few things, and then we'll move on to questions. But on question 5 was about the policy determining rates at the time of transfer. And as Kim touched on, there's a need for certainty from companies, right? We want to know what the rules of the road are. We want to understand what the policy is of the commission, what is expected of the companies from the commission, the public staff. So there's a need of certainty at the time of transfer. I mean, the default should be that uniform rates are to be expected. There are some exceptions that could warrant in a case-by-case basis, and I think those are determined as they come up, right? And it's sort of, you see them when you know them, when you run across them. They're typically exceptional circumstances that take place. So we support the ongoing policy and the general movement to uniform rates because of the benefit for all the customers. On question 6, the establishment of criteria, we've talked about that. I think that's the same thing. We want to know what the criteria is that's acceptable. There may be a range of those. And what defines a a troubled system or a disadvantaged system. I know at one point in time, the commission, the public staff actually used to have a list that they maintained that were under some sort of classification and provided those to the companies, encouraged them to take a look at those, right? So there's been previous policy by former commissions and public staff, putting some type of parameters around those. So I think there maybe just needs to be a dialogue and discussion about, what that is and how we view that. Does that need to be a policy? Does it need to be statutorily put in place? And so we had those discussions and kind of continue to encourage that as we move forward to, again, understand what those are and how we can work through those. And then finally, on the last question, on question 7, talking about the need for knowing at the transfer proceeding, and I think it's been clear that that's critically important to the companies, right? We need to understand as we go in and we go talk to these systems, how we're going to be treated and what the rate base is going to be, at the time. And I think we accept that as a generally accepted practice. So, Kim, unless you have anything else to add, I think we're open to questions.
So we are at 2 hours now, so we're going to take a 10-minute break and come back at 3:10 for questions from the commission. We'll go off the record. Thank you for the presentation. We're going to begin with questions from Chair Mitchell.
Good afternoon. Glad to see y'all here in the hearing room today. Ms. Joyce, I've got a couple of questions for you. I'm going to be quick because I have to scoot in just a minute. But sort of just stepping back a little bit, we initiated this series of technical conferences to delve more deeply into some of the issues that are relevant right now in the state, and that we foresee becoming even more so as we look down, over the next 10 years and anticipate investments the companies are going to have to make. And so, we posed a series of questions in the first order to kick things off. And then there was a second order in which we posed some additional questions. But my hope is that going forward, you all can engage and continue to engage in these discussions in a way that starts to get at some solutions here. I mean, I think at this point, we as a body are aware of investment needs and challenges that y'all are going to have going forward, both in terms of replacing aging infrastructure as well as dealing with emerging contaminants and secondary water quality concerns and other things that we know exist here and are going to exist here in the state. So I hope that y'all leave here today and go away and engage in a way that starts kind of getting more down into the detail and coming back to us with some things that we can really think about. Your point about setting expectations for the companies is a really, I hear that and I understand that. And I think that's where we want to go. So y'all got to give us something that we can react to. And I'm saying this to Ms. Joyce, but I'm also saying that to everybody in this room. I have to leave before you get up on the stand. Otherwise, I'd be saying it to you, Mr. Junis, too. So I hope, and we don't lightly ask y'all to come together and spend your time on an exercise like this. It takes you away from other things. It costs money. It costs your ratepayers money. So, and it takes Mr. Junis and his folks off doing investigations and into the companies y'all or the systems y'all want to acquire. So please make the most of the time, start solving some problems, and bring us some things that we can react to and build upon. Because ultimately what we are trying to do here is set some policies, establish some policies, rethink some policies if necessary. So that's my 2 cents for the moment. But just to sort of tease some things out of you, Ms. Joyce, while I've got you, you're sort of, you mentioned, I mean, I hear in your comments to us this tension between, and sort of hearing from Mr. Schellinger too, acquiring additional customers, and I understand the benefit of that additional headcount for the customer base at large. And then sort of rate base, wanting to understand and know and understand where this commission is going to fall on the rate base question. And, there's going to be some pushback from the consumer advocate on the rate base issue because they're going to, well, I'm not going to restate why they're going to push back on it. Y'all know where they're going to push. So these are the kinds of things. Can you all talk about that sort of rate base expectations plus the value of additional customers and sort of try to get to a place that is workable for the company, workable for the public staff? And the answer may be no. I heard somebody say earlier today that there was no consensus. Well, I hope that y'all can do a little better and at least sort of tease out the issues for us so that we are not just thinking about things at a really high level, sort of conceptual level, but help us understand financial implications for the company and for the customers. There have been comments today about the benefits to the acquiring customers. And I think I hear loudly from the public staff concern in cases that involve acquisitions of systems by utilities, concerns about the acquired customers and fairness to the acquired customers. I also heard from you all today saying, yeah, but those acquired customers might not have been paying realistic rates for the past X number of years. And I get that. But so how do we, help us find some ways, give us some tools to think about striking the appropriate balance. Y'all know the balance that we have to strike in these cases as they come before us. Let's see, there is going to be a question in here, I promise. I am interested in your thoughts quickly about the WISIP, I guess that's what we're calling it. What's the complexity there about adding new systems? So systems acquired post, WISIP. Why is that even an issue?
It's a great question. I'm anticipating a tension with public staff, and Chuck can, correct me, but, I think it's to be determined, in those multi-year rate plans, we filed lists of projects, and those lists of projects, are for certain time periods. And so I think the question is to be determined, from the utility perspective. Plans change, and I think everybody understands that. But what is that delta of change going to be from the original list of projects that we anticipated to what happens in 2 years? And what kind of standard and what are we going to be held to? Are we going to be held to a dollar amount per year in those plans? Or are we literally going to say, you said you were going to do those 100 projects, you didn't do those 100 projects? So I think to the extent that we're adding systems during the course of the multi-year rate plan, we can certainly do that as long as there is a recognition of flexibility within that multi-year rate plan. So I think my comments are, we're just anticipating, maybe it's a false assumption or anticipation, but there might be some tension about adding that to the capital plans.
Okay. So, and let me make sure I'm hearing, there's a question there. It's how are we going to address the capital investment that's going to have to be made in acquired system that wasn't explicitly spelled out or accounted for in the whatever year of the WISIP?
Correct.
Okay.
I think the utilities can come up with a plan to handle that, because there's going to be change, and we can deal with it. There might be a tension there.
Okay. Okay. This concept of a distressed system, I think you even said, it would be helpful to industry to have an understanding of what this commission's view of what a distressed system is. In your experience in North Carolina, and I know you're not always down here and you might not be in the weeds, so Mr. Poole, this may be one where you can jump in here. I mean, has there ever been a situation where there's been a truly a distressed system where there's, well, let me say it this way. Has there ever been a situation that y'all are aware of where there's been a difference of perspective between the public staff and the company about whether a system is distressed?
I would say with my experience, we try to come to the public staff. And of course, this is speaking previously years ago. So there's been change. I want to be clear. There's been change in staff and change in the commission. We tried to come in and have a dialogue that you mentioned earlier and said, hey, here's what we're looking at. Here are some of the challenges that we see, whether it be operational, record keeping. Here's what conversation we've had and what the expectations are. You've heard other people say the dollar offer, right? So obviously we always start at a what we believe is a reasonable offer, or at least start at a offer that can start the conversation. And sometimes we get to a point where we know that they're not willing to sell for what we believe is a rate-based price based on the limited information that has been provided to us by that individual and by due diligence that we've conducted or been able to be provided by the customer. So at that point, then we come to the public staff and say, hey, here's this customer. Here are the challenges that they're having. When I say customer, I mean company. Here's what they have explicitly told us or communicated to us that they're not willing to sell for. And so we think that they have challenge opportunities, and they may not be distressed from their perspective. We may not think they're distressed, but they have challenges, right, that we see are not being addressed by the current operator, and they're willing, or at least have an interest of getting out of the business. And so I think that having that dialogue and conversation of what classifies distressed is the first step. But if there are criteria that can be laid out as were mentioned earlier, like maybe you have a list of 10. If you meet certain parts or look at it, then maybe they get classified. But I think, as you mentioned, it's a give and take, right? We need to have those conversations, but there's got to be some boundaries too, right? So some definitions, so we know that there can be productive dialogue and an opportunity to pursue an acquisition or not. I hope that answers your question.
It mostly does. I mean, has there ever been are you aware of an instance where the company has brought an acquisition target to the public staff and the public staff says, get out of here, no way. We're not going to let you recover more than what this than X amount, even though the company says they want Y amount?
I've had conversations with a former public staff member who basically told me, yeah, I wouldn't go down that path.
Okay, but so the public staff has provided that guidance at times. Okay.
Yeah.
Okay. All right. Are you, Mr. Poole, remind me, are you active in any other jurisdictions that Aqua's in?
Not currently.
Just North Carolina, and you've been in Virginia?
I have, that's correct.
Okay, I'm not going to ask you about Virginia. Let's see. In those instances where Aqua has been asked or been appointed, let me say it this way, in those instances where Aqua has been appointed as an emergency operator here in North Carolina, have you all been able to work out the financial implications of your providing service with the public staff? I mean, has there ever been an instance where you've had to litigate an issue related to your service as an EO?
That'd probably be a better answer for Mr. Becker. I can't accurately answer that question for you.
Okay. 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 All right. Thank you. That's all.
So following up on Chair Mitchell's questions, I think just to give the group a forecast of one of the things that we'll be interested in for the next technical conference is how to about the WISIP and how new acquired systems can be included or added into the WISIP, how we can overcome the challenges that you're talking about. And then I think this is also follow up for Chair Mitchell's question. I think it'll be to you, Mr. Poole, dealing with some concern that we also heard from Redbird about not having a definition of what a troubled or distressed system is. We do have quite a bit of commission orders that either approve an acquisition adjustment or deny an acquisition adjustment based upon whether a system is classified as troubled or distressed. Can you talk about your opinion about, is that not sufficient for the direction that the utilities need in this regard?
It certainly provides guidance, but also in a lot of those orders, they're not precedential, and it clearly states that in the order. So that guidance is great, yeah, but it's not a precedent, right? Each commission is allowed to make the determination one by one.
And so then what specifically are you looking for? And maybe Ms. Joyce, this would be a question for you about if you want a definition, if it's not in a commission order, what are you asking? What would be what you're looking for to provide that kind of specific direction for the companies?
Yeah, I can think of some examples in other states where they, again, it's not a check the box kind of policy, but it gives examples of what the commission considers characteristics of a troubled system. For example, high unaccounted for water. There's, no succession plan, and that's sort of code for the owners are going to walk away in the next, they're in the near term. The system is financially insolvent, right? They have actually no net income coming in, so they can't invest in the system. So there's specific lists of criteria that are examples of a troubled system. I will note that, even with a list of those that I think are very helpful for the utilities in terms of identifying troubled systems, we still argue about them with our consumer advocate, right? Is it 60% unaccounted for water, a troubled system, or is it 40%? So it doesn't take away like all of the uncertainty about whether a system is troubled or non-troubled in the eyes of the consumer advocate or the commission, but it certainly helps. And it, like Ruffin said, puts guardrails, and I can provide that policy. And I think we have a number of them in our states. We can include those.
Okay, that would be helpful. And then moving on, some of the questions that I had was related to your question 6 about, and I think this may be from the presentation, part of the presentation you provided, Mr. Poole, about transfers of the small or troubled wastewater systems. And on question 6, you talk about one of the mechanisms that could encourage that would be a market-based rate base. And so with a market-based rate base, a couple of questions, I'll just go ahead and provide them all to you. How would it work? And then how could you ensure that customers would not be double paying for infrastructure that could have been funded by CIAC? And then just to go ahead and bring my last question in, is it seems like a market-based approach would be somewhat similar to an acquisition adjustment. And so what's the difference? Why market-based as opposed to the process that we already have of acquisition adjustment?
I think you hit it on directly, right? It's just a terminology, right? I think that what we're referring to here is market-based would be similar to an acquisition adjustment, right? This is theoretical. We haven't fleshed this out, right? All these stakeholder meetings and these discussions were to stimulate ideas and dialogue for us to think about things that may help streamline the process. And so in theory, again, one of the things about market-based would be to look at, hypothetically, if you have a rate base of, let's just say $2,000 per customer, and you're looking at a system and they have a small amount of rate base per customer. Let's just make up a number, $100 rate base per customer. And the seller is wanting more, and you can't come to an agreement. You know what the capital improvements are from your due diligence, or at least based under your due diligence and your examination of that system. Then you come to a determination that if you can keep it below your rate base per customer, then maybe that's the market-based determination, right? Again, those are going to be parameters and discussions just out there to have with the public staff and with the commission. It's just an idea to talk about. But yeah, it's very similar to an acquisition adjustment, maybe the same, except just a different terminology.
So you're not proposing that we move away from the acquisition adjustment concept and use market-based approach. You're providing this as another potential mechanism
That's
that you
correct.
would propose. Okay. And would, from Aqua's perspective, would market-based approach be preferable in any way than using the acquisition adjustment tool?
Be honest with you, haven't really fleshed it out, right? Hadn't thought about it or penciled it out. I think the acquisition adjustment is a tool that's been used in the past historically and can be used effectively,
Okay. And then you also, I believe that Aqua's also suggesting that in a transfer proceeding that the cost of service or revenue requirement be eliminated. Did I read that correctly? Is that your position as well? I know public staff disagrees, but are you in agreement with the other utilities?
Yes, that's correct.
Okay. Can you just briefly describe from Aqua's perspective about why not having that requirement would facilitate acquisitions or transfers?
Yeah, I think it's some of the things that you've already heard, right? It's the time, the effort, the bad records that are unavailable from acquisitions or companies that you're trying to acquire. and trying to put the time and effort to piecemeal to make a cost of service study, right? It takes a lot of administrative effort, and sometimes you don't have that information readily available.
And then remind me again, what is Aqua's position about determination of rate base? Or you propose that rate base should be determined at the time of transfer, is that right?
That's correct.
Okay, and you haven't had difficulties in doing that in your transfer proceedings?
I think we want to have it there so we know what we're getting ourselves into.
Okay. Thank you. So I'll, Ms. Joyce, did you
No, go
want to?
ahead. I mean, I was just gonna add, based on experience, in encouraging acquisitions and then, providing safe and reliable service hand in hand, determining rate base in the transfer proceeding, is really helpful. Not just in terms of, getting the acquisition approved, but I'm not even thinking about the multi-year rate plan, but what typically happens, right, when Ruffin and his team are doing these deals is not understanding what the asset is that you're buying and going to own and operate until what could be 4 years down the road. It's very, very difficult. And so I just want to put that in some context. I mean, that's what we've done in the past. And many of our jurisdictions are establishing rate base in the transfer process. And it's, if we're going to have a disagreement or argument about it, why not have it in the transfer proceeding? It would be our position.
Okay. Thank you. So I'll check with my fellow commissioners to see if they have any questions. Commissioner Hughes.
Yeah, so I think we often boils down to rate base when we're looking at positions of distressed systems. We have in North Carolina, and I think it was a result of a stipulation. We had an effort to try to create an incentive in your incentive account. Yep. And I realize this is a stipulation of the particular situation, but it has been on the books. And it does seem to be innovative. And just would love to have your comments on how that has proceeded and detail, but it doesn't seem like it's flown off the shelves as far as its use, but I could be mistaken. But on paper, it looked like it maybe it's a percent of that turned out to be.
Yeah, so you're referring to the AIA, the acquisition incentive adjustment.
It's old.
Yeah, that's okay. We file a report on that on an annual basis. So while I don't have the numbers off the top of my head, you can look at that and see all the previous acquisitions that that Aqua has utilized that tool for and the amount of money that has been given to credit sort of our goodwill in the acquisition when Aqua purchased Heater. There was goodwill established. So the AIA was part of the settlement tool that incentivized Aqua at that point in time to acquire small and troubled systems to draw down that goodwill utilizing an AIA. And the AIA, again, was a negotiated tool. We did know some parameters, and I know historically there were discussions, and oftentimes the public staff and the company, and this was prior to my time, so I'm kind of speaking a little bit from just being around some what I call the old timers and some discussion I've had, that we would disagree on the amount of money that we would look for in the AIA, and ultimately the commission would make the determination on that amount of money. There was a cap, right, that we were allowed to credit down on based on each of those systems. But it was a good tool, and I think that's a great example that a tool that the commission could adopt to encourage companies to acquire troubled systems, right? Outside of the benefit that Heater or Aqua received from the Heater acquisition.
I thank you for that. what the balance is on that?
I don't off the top of my head.
Okay, Commissioner McKissick.
And this is just to follow up on what's already been said to some extent. I know I asked that question of Redbird as to what constitutes, a distress system, what are and they went through this explanation about what's done in other states about the various parameters. Do you think it's likely that you all could come to some type of consensus or try to identify what the best practices might be for making that kind of assessment? It sounds like you will feel as if there is some information out there that you could bring back the next meeting, but could you elaborate on that a little bit further? Because I think that would be helpful if there's an opportunity to review those parameters and for us as a commission to begin to consider them, and if that can be done in consultation with public staff, that would be excellent.
Yeah, Commissioner McKissick, I think that obviously going forward, we know there are going to be more technical conferences. We're going to have stakeholder engagement with the public staff. And I think that's a perfect topic to tee up at our next stakeholder meetings, right? For us to have that discussion. There are criteria that are out there. And obviously it's just trying to determine how to frame that criteria, what fits into the criteria to make it work. So I think that's a great suggestion for us to take forward and the companies to work with the public staff to talk about those items and say, hey, here's some parameters that may make sense.
Yeah, and it would be very helpful to us as a commission, and you shouldn't have to rely upon, precedent that may or not be true precedent based upon a change of commissioners or change of public staff employees. So I think if we could really we'll use the word codify, but maybe there's a better term of art to use in referring to it, get there and arrive at what those parameters might be. It would be excellent. Thank you.
Commissioner Brawley.
Thank you, Commissioner. Ms. Joyce, there's been a lot of discussion about affordability, particularly for lower income folks. But Aqua is the only one that's actually suggested subsidized rates. And so we would have ratepayers actually paying down the rates of others. Some might even see that as another form of the income-based rates that California is proposing. And I was wondering, where is the authority for this commission to order differential rates of that type?
Yeah, it's a very good question. And I'm not an expert in the particulars of the law here, but I would say from my experience, most states have general statutory law that says you cannot set discriminatory rate making, right? And I think when when commissioners or public staff or the utilities have concerns about these types of programs, they refer to those like universal rate making, principles that are, have been for a long time. I mean, I would just say I personally believe that when you read those statutes, there's room to interpret the statutes that there's an ability to have some level of subsidy. And the policy reason behind that subsidy is, setting a safety net for our low-income customers can actually be a cost saving that helps our paying customers, right? Because you're helping with bad debt expense. You're not sending a crew out to terminate a household, right? If there's a small portion of the revenue requirement, and that could be set with input by the public staff, with input by the commission to help a small subset, hopefully, right, within our customer base, that actually can be a cost savings in the big picture. But to the direct answer, it's a hard one, and you're not, many commissions and state policies do not agree, and they will say you cannot do this through the rate making process. I just personally believe that if you can read that statute to allow that doing so is in the public interest.
And I can add a little to that if you wish.
Please briefly proceed, Mr. Drews.
Yeah, so the commission is charged in the statutes with setting just and reasonable rates. 62-140 is a statute that says there shall not be unreasonable preferences or advantages or disadvantages. So the statute actually gives the commission the authority to set rates that are different among different customers as long as it's not unreasonable. It's been done in DSMEE for a good time. And so if you have a legitimate policy reason for making that distinction, I believe that would legally be considered a reasonable difference in rates, not discrimination that's unlawful under our statutes.
Can I ask a follow-up? Isn't that reasonableness that you're referring to what allows utilities to charge lower rates for customers with a much lower cost of service, like a large industrial facility? And I think there are economic justifications for doing that that would support the reasonableness test. I think on the other, this is a more subjective point of view about what's the purpose of rate making, or I think it's an issue that actually hasn't been addressed in the statutes before. Now, I'm not an attorney, but I did practice law without a license for 8 years on the floor of the North Carolina House. And sometimes I think like a legislator. They fuss at me and they're trying to get me out of it, but I'm concerned that people are seeing something in the general statutes that is not there. Thank you, Chairman.
Okay, with that, I want to thank both of you for your presentations and coming in today. And we will move on to the public staff's presentation.
All right. We'll try to be timely with this. I recognize we've gone a good chunk of time. I think it's a valuable conversation. I want to recognize Chair Mitchell's point of, jumping into that next step, right? Sorting out details, bringing you something to really chew on and potentially put into action. So I think it's already been announced. I'm Chuck Junis with the Public Staff, Water, Sewer, and Telephone Division. I've worked here now, it'll be 11 years in April. That has been a joy and a curse at times, it feels like. I've worked on a range of cases, including, coal ash with, both Dukes and Dominion, and then have really honed in on water and sewer issues in my time here. I've learned from a lot of institutional knowledge. I mean, I think there's an insinuation of the legend of Bill Grantmeyer and Winley Henry on the accounting side. So just really trying to absorb knowledge and put it into action, learning from the past, but also recognizing sometimes change is necessary to make sure we're doing a good job for customers while balancing the needs of the companies. So just hitting very quickly the 7 prompts, but then I want to just address some of the questions to the other parties and some of the previews of questions that were going to be coming towards me. I'll try to make this as efficient as possible. So should they be grouped? I think it's really a question of can they be grouped? And then it is a question of should they be grouped? This concept, when you get into grouping, so we can either have system specific or even just groups of rates as currently exist. Carolina Water has 4 rate divisions. Aqua has 5 rate divisions. So you already have a semblance of grouping, but that is based on cost of service, right? So those are specific revenue requirements where costs from those specific systems are quantified. If you move to, say, a one water, one sewer revenue requirement, now you are lumping even more systems into one revenue requirement. And I've heard the parties talk about, well, then you can use rate design. Well, when you try to do that, you're then, for example, the tiers that Redbird talked about, you're then sort of doing cost of service, but without the cost of service. You're trying to associate cost differences, but you're sort of approximating. So should tier one be 20% higher than tier two or vice versa? Well, why not just keep the costs separate and do a cost of service and have the rate, have a matching principle, costs with rates and revenues. So I think we got to be careful of balancing that. You want to throw all the costs together. And I don't know if any of you are, bakers or just people that eat food, right? Like you're combining the ingredients, you're mixing them intentionally, and you're coming out with a product. And sometimes it turns out really great. Sometimes it turns out really bad. It only takes a slight difference in the quantity or how you mix those things of how that result is going to come out. Well, you want to then take that result and try to pick it apart and pull out the ingredients. That's almost impossible to do. So I question that approach. I'm not saying it can't be done, but we got to really think through the implications and what is the intention? What is the policy and goals of this commission, which will be influenced hopefully by the parties to protect customers. So just, we got to be thinking about this stuff when we're making these decisions. I think broad generalizations can be dangerous. You got to look for some of those potholes or pitfalls. And so that's what I'm warning against. Item 2, I think there is a difference of opinions in terms of incorporation into an existing multi-year. We're only right now dealing with the first annual review stemming from the WSIP. It's not easy. Even though we tried to think through this as much as possible, getting these reporting requirements right, understanding some of the real implications and feasibilities, timing, when are costs coming in and being final, so then you can determine whether a metric is met or not. There are real challenges to that. And I've heard comments about efficiencies and administrative burdens. When you talk about modifying a process that we're barely doing for the first time, I think there are inefficiencies to that. I think there are challenges to that. If we think about this next multi-year, then maybe I think it's viable. But to say, oh, let's start incorporating newly acquired systems and put them into this multi-year process that we worked really hard on. The parties discussed these things, ultimately came to partial settlements to determine what are these reasonable projects, looking at and scrutinizing the type of projects, the plan, the cost of service associated with all the systems that were part of that WSIP. And now you want to throw in new variables. Those new variables present new challenges. I also question, what's the benefit of rolling them in? I think it is tangible to take acquired systems, track them, and then it is a question of should they be incorporated into uniform at the time of the next general rate case. That way, not only do you hear from the acquired customers about that integration, you hear from the existing customers. I think that voice is left out in a transfer proceeding if you're determining whether they should join uniform. And I know currently most acquisitions are relatively small in comparison to the existing. That could change. We've gone through our first fair value acquisition. I don't know if there's another one on the horizon, but there are municipal and government-owned utilities that are far larger than some of our private utilities. And so that could be a complete game changer when you talk about impact to uniform rates. So I don't want to formulate, this is the default, and not think about, well, hey, there could be a 900-pound gorilla out there that totally wreaks havoc. So just, again, trying to think through some of these details. What are the implications? I think it is a fair point. I think everybody recognizes affordability, but I think there is an issue of where are we going? What can tangibly be done within the current statutory framework? Mr. Drews mentioned GS 62-140. We put that at the tail end of our presentation. There's room for interpretation there. It's my understanding, I'm pretty sure there's like a bill credit system that Duke has for customer assistance. So that's one mechanism that's been put out there. I think there's tangible ways to do rate design that isn't explicitly an affordability or customer assistance program, but could contribute to affordability. I think that's lower base charges and access fees. I also think that conservation rates is an option as long as it is thoughtful. Because if you start raising rates in those tiers too soon, it could be a disadvantage to like lower income, older communities where they may have less efficient appliances. They may have leaks on the customer meter side that are harder to account for and fix, and thereby would be a penalty if a conservation rate isn't designed properly, or have some of the customer forgiveness when there is a leak. I'm going to keep going here. Acquired systems, the systems with a lower cost of service, and I think Kim Joyce acknowledged this. If you charge them the uniform when you know they have a lower cost of service, you are essentially overcharging them, especially if you are not passing the benefits to the existing customers. So if that makes sense, if their cost of service is lower, but you're charging them more, well, that means they would be compensating for a greater portion of the revenue requirement. So thereby, there should be a savings. Might be relatively small if it's a large customer base on the existing side. I think Matthew talked about that in terms of effectuating that cost savings. Well, that gets effectuated in a rate case. Otherwise, you don't see that impact. So we would be very much opposed to putting a uniform rate on a customer base that has a lower cost of service in a transfer. You can consider whether they be incorporated into uniform in the next general rate case, but set those aside. Like he says, operate them, learn what the planned improvements are, incorporate potentially those planned improvements into the WSIP, but in a general rate case where all customers can be heard. Yeah, I mean, we're definitely case-by-case basis. There are extenuating circumstances in many cases, and we think that the cost of service is important. So talking on question 5. Question 6, to that point on efficient transfer, administrative efficiencies, efficiency, how do I want to put this? I'll come back to that one actually, because I have some notes separately. Rate base acquired systems established. I think most of the group agrees establishment of rate base at the time of transfer, this is prompt number 7, is important. That is some of the certainty that the utilities are seeking. Because if you don't have that certainty, who's carrying the risk? Now, I know the argument was that the company carries all the risk because they paid the purchase price. If they defer to the decision, I would humbly disagree, because I think there is some deference to cost incurred being sort of presumed to be recoverable. And so then is it a matter of, is it reasonable or prudent? Is there a purchase acquisition adjustment? Do we have to fight about whether it is operationally or financially troubled? The discovery of additional documentation after the fact. The seller should be most motivated to provide documentation during a pending transfer. That's how you justify your purchase price, right? The lesser of net book value or the purchase price is the bar initially. You can try to seek a purchase acquisition adjustment, but that is a different set of criteria. So the seller should be motivated. I think there also needs to be proper downward pressure on purchase prices. Some of that dialogue that Ruffin's talking about, I would speculate that he carries that back to a potential seller and says, we're going to have a hard time getting this approved at that purchase price. We need to renegotiate or talk at a lower purchase price if you really want to be out of the business. I think some of those iterations are missing on some of the purchase prices we've seen in cases of recent memory. So that hits those points. I just want to make some overarching suggestions in terms of guiding principles when dealing with this uniform issue and some of the concepts that the commission has addressed. Case-by-case analysis and consideration is reasonable and necessary in most cases. Rate consolidation should be accompanied by, I would say, guardrails or protections for customers. We need to maintain or even strengthen the prudence and reasonableness standard. When you start throwing, it's sort of the concept of dilution. If I throw a drop of dye into a bucket, you're going to see that relatively clearly. If I throw a drop of dye into an Olympic-sized swimming pool, it's probably not going to be hardly noticeable. That's sort of what is happening. And to, I think it was Carolina Water's point about easier to justify capital investment in smaller systems. There's a greater level of scrutiny if you're talking about $1 million investment that directly impacts 100 customers versus $1 million investment that impacts 50,000 customers. There's just a different sensitivity to that investment, a different pressure to seek out lower cost alternatives or at least consider alternatives. I think in some cases we're not even seeing that. This is our preferred way to fix this problem, and that's what we're going to do. And it becomes the reasonableness and prudence standard is very hard to prove. So when we recommend disallowance, that's challenging. So there's some level of enforcement here that needs to happen when you move more and more towards a uniform. Affordability tools has already been hit on to some degree. Protection or assistance for financially vulnerable customers. Rate design. Some strategies that I think could be implemented right now. Low access or base charges. Strategic conservation rates. Smart growth and consolidation. And I use the term smart because, we talk about SMART goals for accountability for our employees. I think smart growth and consolidation involves physical connection of systems to actualize economies of scale. Because yes, you can have some economies by, decision making, but real economies of scale come from connected systems, including, I think this needs to be addressed in purchases. I think it needs to be addressed in sales and regionalization. There needs to be some acknowledgement that the closest utility should be the first choice when establishing new systems or even for transfers. So when you start talking about market, I think one of the alternatives offered by Aqua was sort of this market value option. I think that turns into a bit of a bidding war. And so then where does the priority of who can provide the least cost service? Who has operations nearby? Who would be an option potentially for physical connection if things go south? We've seen systems run out of water. Our state has been pretty resistant to drought to this point, but there are areas of the state that are facing real issues with water capacity. And I think that could be an issue that we're facing in the future, either by capacity or by quality issues and the cost of treatment making it near impossible. I think there's also needs to be acknowledged, there's a natural incentive for the private utilities to acquire systems that need investment. How do they make money? It's the return on their investment. So if it's a low cost system or a low purchase price system, they can still make money off of it by investing into that utility. So there's already sort of, I compare it to parenting, the concept of natural consequences. Like, all right, if you want to, skate without knee pads and then you fall and you scrape up your knee, that was a natural consequence. You could have worn that knee pad and protected your knee. There are also natural incentives here for the financial aspect for the utilities. For the companies, single revenue requirement, one for water, one for sewer. I think there's a disincentive to cost control because of that lack of sensitivity. It's sort of dilution of transparency is not the solution. Like I said, throwing that drop in the bucket versus the drop in the pool. I'm going to zoom ahead for the purposes of time. Where are we going? And I'm glad Chair Mitchell commented on this because it was helpful, because I was asking myself this question of, okay, what do we do next? We've had these more general conversations. I think there is a need to get kind of into the details, get our hands dirty. So what do we do? I think data from the companies is important. We have seen no analysis, even, for example, let's look at rate year 3. What are your current rate divisions, uniform rates, we'll call them, and where would a one water, one sewer rate really land? How much of an increase would it be for Fairways Water to be part of a one aqua water rate division? What would be the impact for their uniform water? What would be the impact for Brookwood? Let's really start to see some numbers of where does this go? What are the implications for customers? I think we also need to start seeing service area boundary data. That feeds into regionalization. It feeds into new CPCNs to be considered. Who's closest? Who can provide efficient service? It also goes to income data. Where are Carolina Water's customers? Where are Aqua's customers? Where are Redbird's customers? And can we match that with census data and really assess what is their income level and what can they afford for rates? Because that feeds into these mechanisms, the customer assistance programs. I think there was just a couple more items from what was discussed today. Funding for the environmental regulators. I think Mr. Silas hit on this. We see that. DEQ is stretched pretty thin. We try to collaborate with them. It's important for accountability for these small water and sewer utilities to try to identify who is non-compliant, who needs help. And they are vastly understaffed. We've worked closely with the Washington Regional Office. We've had success with them, Outer Banks, Kinnicky. Appointed an emergency operator, the moratorium's now lifted, but they are operating at less than 50% staff. So they face challenges. Well, what can we do to supplement that, to do our jobs with our private utilities? The commission has available GS 62-42, where they can order actually deficiencies be addressed, improvements be made by the regulated utilities. I think we're gonna have to start coming to you and having you flex that authority to sort of take action. So it's not just identifying who needs to be bought, but who can actually make improvements and just isn't being held accountable for the quality of service that they're providing. Commissioner Cameron, you hit on tiering is essentially standalone rates. That was my comment earlier about you have cost of service studies to design standalone system rates. And then you have tiering, which is on the opposite side of you've grouped all these costs and now you're trying to separate them out. So I do tend to agree. They're similar concepts, but I don't think you can do it as accurately when you've already grouped up the costs. We've seen that in challenges of removing retired systems or sold systems out of the cost of service and trying to quantify, well, what are the expenses and what is the rate base associated with that system? Once you've thrown it all in the same bucket, it's harder to get out. They can do it, but they will say it's administratively difficult or it's inefficient to do so. So I just want to keep that in your guys' minds, and I agree with your comment there. One more, I promise. Well, maybe two. Ms. Joyce commented on iron and manganese and secondary water quality. I do agree. That was a huge issue. We worked together. Those costs were mitigated because of uniform rates to some degree. But where did the scrutiny come from? The public staff met with, and this commission pushed for action on secondary water quality. We were going through executive summaries. We were meeting with the company regularly. There was scrutiny about what those projects looked like, whether a filter was needed on a system or could another well be utilized more effectively? Was there lower cost approach? So there has to be a matching scrutiny. And so when you move again, more and more towards uniform, we're diluting the details on the cost and making it more and harder to provide that adequate level of downward pressure on costs. And the other thing Ms. Joyce hit on, the anticipated tension. I think everybody's, lifted weights or exercise, what is the resistance to that tension? Is this a high resistance, low resistance? Is this a heavy lift or a low lift? I think right now we view it as a pretty heavy lift to incorporate newly acquired systems into the WSIP and question that the benefits offset those challenges. She mentioned the list of projects. I think that gets into just the sort of theoretical differences between the public staff and the utility on this was a set group of projects, a list of projects that we expected to be implemented and customers expected. There are customers that looked and said, hey, that's my system. I'm seeing an impact. That's justifying that rate increase. But if the utility has the flexibility of, yeah, that list, we're hitting a dollar amount. Those are no longer priorities. Well, the customers were sold a bill of goods and impacts or benefits that now aren't being delivered. I don't think that's right. And I don't think that's what the public staff envisioned when supporting the WSIP and the implementation of projects and the recovery of those costs prospectively. All right, I'll stop there for questions. I think I hit some preemptively, but fire away.
So Mr. Janis, you provided a lot of information there. So I'm going to start. I've got some questions. It's going to be a little bit disorganized because a lot was said here. I'm going to start kind of toward the end of your presentation. You talked about it's important that that the commission become aware of these and identify these troubled systems earlier rather than later. And that's something that we do want to see. We want to have public staff and parties identifying the systems before they become emergencies, before they're in the news, before emergency operators have to be appointed. So that's something we're actively trying to solve that problem. And we need the help from public staff, as you're doing, and the parties. You mentioned toward the end as well about data that you're looking for. Concrete things that public staff would like would be Service area boundary data, don't you already have that? Isn't that already included in CPCN applications or contiguous extension requests?
So similar to the industry, it is fragmented. We have maybe physical maps. Not all the maps were scanned into the commission's docket system. So we're somewhat reliant on our paper files. And again, it is service area by service area. And we really don't have that overarching sort of database of, okay, why can't I search an address and be able to answer a customer question or a realtor of who has the CPCN for my home? And so we really don't have those boundaries in a compiled fashion. We are working and need to continue to develop that relationship. Carolina Water agreed to meet and discuss their GIS data, and we need to take advantage of that. Conflicting priorities we haven't developed that, but I think it's across the board. We need to be addressing this with all the utilities to know exactly where they are and evaluate transfers. Who's closest? Who are the options that should have been involved here? And again, that downward pressure. But
Well, I do agree. I mean, I know that not having the data and the maps for service territories is long since has been a problem for a number of years, and I think that that's something that that we all need to be trying to solve. But for the newer systems that are being acquired, that please tell me that that is not an issue, that you are receiving accurate maps and information of
we are
service
pushing
territories.
for accurate maps, again, electronically available, and sort of that compiling that company-wide coverage area is important. Because again, we're referencing back to essentially paper documents or a PDF of a service area specific to 100 homes or 50 homes. And that is not functional data, right? I think there's a difference of, I think I have it over there. W-100 sub 13, where the commission was talking about uniform rates and the viability of that, and then the data associated with cost of service. That's real nice and all to have that paper printed, but it's not very functional to pull out what were quotes, searching terms, to really utilize that information. So I think we got to get to that point. We have to modernize.
And Chair Mitchell talked about how we're going to be having additional technical conferences, and so we are going to be coming forward with an order that's going to be providing specific direction about what we're looking for and specific information about how to solve these problems going forward, so that we could do something to act upon these different issues for the benefit of the customers and the utilities. So one of the things that I'm confident that will be in our order is that the public staff will have a different opinion from the utilities is the pros and cons about including newly acquired systems in the WSIP. And if it's to be done, what are the best practices for doing so to provide benefits to customers and the utilities as well? I know that the public staff disagrees with the utilities position about that. We also are going to want to hear more specificity about grouping for uniform rates. And I noticed, Mr. Junis, that you have a lot of different options for potential grouping of regionality, treatment, source, type of acquisition, purchase acquisition adjustment, system age, socioeconomic status. So we're going to be looking for more specificity about how can that type of grouping be done in a way that makes sense. Another thing that we're going to be asking about that we haven't heard the public staff's perspective about is we have heard from the utilities that they want more direction about what is the definition or what is the criteria for a troubled or a distressed system. And as I mentioned, I believe in some previous questions, we do have commission orders that provide some direction, but the utilities say that that's not enough direction. What is the public staff's position about whether there is enough current direction to the utilities to know what a distressed or troubled system is and whether we need additional criteria and definition?
So I think there is, substantial commission orders speaking to this. There are a number of inputs that impact whether a system is operationally troubled or financially troubled or both. But I think there is pretty substantial guidance there. Now, to Ruffin's point, do you have discretion to buck from that trend, or have discretion to give your own interpretation? That's a legal question that, while I'm not going to dive into, I think it's a great prompt for us to address in future technical conferences, but I think there is information there. I think then the other question that pairs with that is, what is the implication if it is financially or operationally troubled? You still have to meet that requirement that customers, either the acquired or the existing customers, be no worse off, right? And so where is the quantification of benefits that offset the costs of that purchase acquisition adjustment? I think that's what the companies are struggling with, but they're not doing it. We're not seeing a quantification of the benefits that would offset that cost. So it takes, pardon the pun, but two to tango, right? We need information. We need it to be complete. We need it to be accurate. If you don't meet your burden of proof, then you're not going to get the your requested outcome.
Mm-hmm. And so, Mr. Junis, I hear what you're saying. I think those are two separate legal issues that the commission has to address about whether system's troubled, and then also considering benefits to the customers. But I think for the order that we'll be issuing, we will be looking to determine whether additional direction is appropriate, and if so, what that direction will be, just to give all the parties notice about one of the issues that we think is important. And then about uniform rates again. Can you respond to, I think all three of the utilities have talked about that they're in favor of more uniform rates unless there's an exceptional circumstance that would justify deviating from uniform rates. And I think Carolina Water and Redbird specifically said that that over the long term, there wouldn't be subsidization of systems, because all systems are going to need investment regardless at some point. And so that helps to keep investments appropriate or able to be done for the perhaps the smaller systems. Can you respond to that? Because I think that's a good point, that all systems are going to be needing some type of investment.
So I'm going to apologize for disagreeing with you, but I think that's one of those generalizations that it can be dangerous, that not every system needs the same level of investment. There are low cost systems, say a water system that is, a couple of wells, that has minimal chemical treatment, no physical filtration or costly treatment. And, that is going to be a lower cost of service system, no matter if you have to replace that infrastructure, in comparison to a system that has maybe a PFAS filter, or is in a location where you have more main breaks, perhaps a mountainous area. And then same thing on the wastewater side, like Mr. Silas was describing with the lagoon systems versus the mechanical treatment. You could have, say, a very modern technology but poor economies of scale system that needs replaced over and over again, that will always be a higher cost of service than a lagoon system with good economies of scale, even if you need to replace the collection system. So yes, there is a cyclical piece, but you're also you are deflecting from or diverging from the matching principle of costs, and some aspect, the generational costs. So I pay for insurance on let's say my system's new and it was contributed. All right, so I should have a really low cost of service, right? And I should pay lower cost rates to account for that. But if I pay uniform and that's higher than my cost of service, I'm paying the insurance for potentially a future customer. Because let's say that distribution system needs replaced in 50 years, well, I might not be a customer anymore, but I paid the insurance so then they can get lower cost of service. So we got to deal with that a little bit. If ultimately it is the commission's policy or goal for uniform rates, then we will work around that. But there still needs to be some of those guiding principles about scrutiny of costs, affordability. So I just want to caution that there are implications, and not every statement it can be applied so uniformly. It's not a one size fits all or one shoe fits all.
Okay. And so I'm gonna wrap up with two more questions and then turn it over to the commissioners. Okay. So two more questions. We've heard from the utilities that they think that having to determine cost of service at the time of transfer has been burdensome or administratively difficult. Can you respond about whether you think it is too burdensome on the utilities to provide that information and have that be established?
Okay. I think it depends on the circumstances. So if transfer is at existing rates, typically the cost of service is not highly scrutinized because that is an approved rate. What is scrutinized in those situations is rate base to support the purchase price. Ultimately, we think that is very important because if it's supported rate base, those are costs that customers should pay for. If it necessitates a purchase acquisition adjustment, well, then there should be the information to meet that criteria to receive that purchase acquisition adjustment. And so it really dictates what direction you're going to go. But it is all intended to be a protection for customer rates. Why should you pay, like you said, I think you referenced it earlier, pay twice for infrastructure? That is not effective cost making or cost rate making. And you also get into pancaking. So I really struggle with that. Again, the seller should be motivated to provide that documentation. That should also be downward pressure on the purchase price. I understand the concept of, well, this is the get me out of the business price, but are you willing to accept, a little bit less? Or this is what you're giving us documentation for. So do you need to have an eye-opening experience on how this process works? I think that's also something that we're hopeful customer or company education stemming from the Small Water and Sewer System Task Force can help address, sort of resetting expectations of our utilities of how rates are set and also how a purchase price is supported by net book value.
Thank you, Mr. Junis. Commissioner Depley?
Good afternoon. Thank you for your thoughts today. So the first thing I wanted to talk with you about is regionalization and obtaining more cost data regarding the service areas. How are all of the companies supportive of this project?
We've met some resistance on the sort of mapping concept. There's concern about security, which I would argue system boundaries shouldn't be a security issue. If we were trying to pinpoint infrastructure, then I could understand that to some degree. But where your service areas are, I don't believe should be a security issue and should be publicly available information. I think home buyers, I think consumers should know who are their utility providers. And I think a mapping mechanism would be very helpful.
And so if you did obtain this map, I mean, how would I heard you talk about lease cost but how would you envision the public staff using this type of mapping?
So for example, if there was a new CPCN, and I think I described an example last time of if there is an adjacent utility, that is likely going to be the most cost-effective provider. And so if a new utility comes to the commission seeking a certificate of public convenience and necessity for that, well, is that truly in the public need? So that scrutiny can't be done without that sort of mechanism. We've seen applications where people completely misrepresent who the closest utility is, and we only know it from experience. But there's only so many eyes that have that level of familiarity with some of these systems. So that's one aspect. Transfer is the same. Why isn't another utility involved here, and starting to really question what is in the public interest? Just because you were the first to find it, or if the word of mouth got out there that you're a partner or somebody that's looking to buy, well, that doesn't mean necessarily that you're the least cost provider.
Okay, thank you. And then going to your number, I guess it's on page 9, number 6. You were gonna circle back to this, but I had a question about the concerns. So it states public staff has concerns about formulating definitions. And we heard some speakers today talk about it's not just like checking the box and you're in. It's more of a putting guardrails around the issue. And can you respond to that, please?
Yes. So
And when you're responding, what are your specific concerns? Because this seems more general than maybe it could be.
okay. In terms of the efficiencies of a single consolidated application.
Yeah, but no, I'm just talking about, so talking about definitions, so of a
Okay.
troubled system.
Yeah, it seemed like there was an appetite to sort of create a new definition or new category that would be eligible for some streamlined process or even a new incentive. And I'm pretty cautious about incentives because ultimately that's just a higher cost for customers. So you need those matching benefits. So that's my concern of how are we going to get us to agree on definitions and parameters in this process? It's essentially 3v1 on some of these issues that we don't agree on. So that can be a challenging dynamic to try to get consensus on what does this look like. I did press the utilities in the stakeholder meeting of, well, what are the criteria? What are you thinking? Like, what does this look like? They turned the question back on me. But I said, I'm not the one as motivated here. If you have the concern, then you need to come with the potential options, and then we get to scrutinize it. I don't have to solve every problem for you type of approach.
Okay, but getting back to the second part of the question about what's your response to, it's not a checking all the box with the troubled systems, it's kind of getting guardrails. And tell me if I'm wrong, public staff has a problem with that and wants to use the existing kind of commission orders for that? And
Yeah.
just what is I'm just pressing you on what's the problem with maybe setting some guardrails?
I think there's some concerns about how those will be utilized. And are we sort of pigeonholing ourselves into a situation without considering sort of the unexpected consequences of that, or the bigger acquisitions? How are we defining these terms of small or larger? Or are we just saying troubled? And what falls into some of these categories? So it's hard to really get into the details without being pressed with a detailed option, if that makes sense.
It does. So thank you.
Commissioner Hughes?
It seems like we're going to keep going with this exercise, and there's going to be plenty of opportunity for more details. So I was about to ask for late filed exhibits and things like that. No, we're not going to do that. I was just going to place a bookmarker in something, and then hopefully we'll hear more about it. I asked about the acquisition and incentive account. I've kind of looked it up. I believe there is literally millions of dollars of that incentive that one of our predecessor commissions created, thinking that it was a functioning useful incentive, and maybe it has been functioning and useful depending on your definition. But to me, when I read the terms of it, and for my new colleagues, I can explain how it works later, but it's a very juicy incentive for rate base. You can juicy. You can put that.
That's a term of art, I think.
Yeah. No, I think that's official economist term for a good economic incentive. But I would like in the future to understand better, both from your side and from Aqua's side, why hasn't that been used more? I mean, I think that we know that what we're trying to do as far as these smaller systems is really difficult. I think it seems like we're going to need incentives, carrot or stick. And you've talked about, more focus on the stick. There's some general things about the incentive, but I would be really curious to hear next time around some more specifics.
And Mr. Junis, we're not going to put you on the spot to have you answer this now. That can be something that we can consider for the next technical conference when all the parties can look into it.
With 1 minute, I can give the quick summary of how that mechanism works and then where it's at.
Okay, 1 minute, please.
All right, ready, set, go. So the way that mechanism works is the investment that Aqua makes into one of these troubled or distressed systems that we deem as eligible for this mechanism, they get rate-based treatment, essentially $2 for every dollar of improvement, which is sort of pulling down this purchase price premium. So you get the dollar for the investment that you made, recovery, but then you're pulling down essentially a purchase premium that was paid. So that's sort of the acquisition adjustment that is kicking in later. That's the fast overview, and I got done in less than a minute.
Commissioner Tucker?
I'll do mine less than a minute. Let me ask you something. Why do you have a problem with transfer price and someone paying a lower cost of service and they're being charged a uniform rate? Before you were born, I was paying a KW rate at Duke for them to improve the system. So when you came along, you could have power at your house and the KW price 11 cents versus the 6 or 7 cents I was paying. I had no choice in that matter. What's your heartburn over that in 1 minute or less?
So my heartburn is the matching principle of costs should then translate into rates. And so for these systems in between rate cases, if you've been acquired and your cost of service is lower, why shouldn't you pay a lower rate until this commission determines that it is appropriate to consolidate you into a uniform rate? At which point, again, the benefits of you paying more is shared with the other customers. That's the effectuation is the key.
The other thing, do you think independent testing would help determine trouble systems before it even gets to us or to you or to?
So there are situations where independent testing is probably appropriate. I think, DEQ is trying its best. DEQ does have the ability to take special samples to confirm sampling. So if they have suspicion that this doesn't seem right, how could you have compliant water quality if none of your equipment works? That's not how treatment is supposed to function. So when there's that scrutiny, they do try, but again, with the lack of funding and
no, I didn't turn it on. Would it be a quarterly or biannual basis would be helpful? Or not?
I think it depends.
Okay.
That's a really difficult question to answer because some testing is much more frequent than others, and it depends on if we're talking water or sewer. But yeah, it's a little more nuanced than that.
One last question, Madam Chair. Bill mentioned earlier that he was in the legislature and I was too, and we had to write bills. And lots of times those bills may have had some unintended consequences or something left out. But why is there a concern or fear of writing out the criteria of the definition of a trouble system by public staff? Now, you said earlier that you're not going to develop the criteria for the utilities, but the utilities have to come to you and see what you think is a criteria. So it's a moving target. And we talked about business certainty. Why can't you write your definition for a troubled system in this process that that Chair Mitchell talked about getting to a consensus on between the two of them?
So I could probably write them. They're probably not going to like them. So trying to build consensus, I think they are much better off coming up with a proposal and then we scrutinize it as instead of the vice versa. I also think, my concern is you are trying to create something and cater it to a specific set of circumstances. And you do need to try to contemplate what would be an outlier that could be misused. Because if you're talking about an associated incentive, how could that potentially harm customers? So I'm just trying to do my job to
I
protect
understand,
customers.
and you do it well, and
Thank
I appreciate that, but that's also a legislative bill that you write when you don't know what the circumstances are, nor all the answers, nor all the criteria, and you have to put it out there, and then you have to back up on it later on. So, I mean, I hope you can, in these meetings, you guys can get together on what your criteria is that they wouldn't like and what their criteria is you wouldn't like and come to some sort of consensus. Thank you, Madam Chair.
So I think we're almost very, very close to the end of the questions. We have one quick question from Commissioner McKesson.
It's really more of a comment. First, Chuck, I want to thank you for your passionate, principled advocacy on behalf of the public staff and the using consuming public. I think you've always done an excellent job with your analysis.
Thanks, sir.
And the thing I would say, obviously there may not be a meeting of the minds on some of these more contentious issues that have come up today, but to the extent to which there can be some consensus reached, or at least the areas of distinction can be minimized, that would be outstanding. But I understand the whole concept of the outliers that might be out there, like the fair value proceedings. So, I mean, I get it. So, but
Yeah.
thank you.
And I'll just answer, comment on that, we will make a good faith effort.
I know.
These conversations are not just myself. I really do. I mean, y'all have seen, we have compromised. There are settlements, even in some of the toughest cases. And the public staff is certainly a driver in that to hopefully reach, resolutions that both protect customers and adequately balance the needs of the companies. So I know I'm passionate and it may seem like I'm, adversarial in some aspects. There is also a level of, negotiation here. And so I'm not going to overgive on the behalf of the using and consuming public when it's not necessary. I'm trying to get the best outcome for them.
Very well stated.
Okay.
Thank you.
So I want to thank all the parties for, first of all, doing the 3 stakeholder meetings and coming in good faith with a lot of information to try to help us resolve these issues that are not easy to find solutions for. So before we go off the record, we will be issuing an order in the very near future because we're going to have another technical conference. And as you heard, we're going to be looking for additional information, but really, I think more specific action items that the commission can then attempt to act upon to try to address some of these issues and problems. So thank you again, and we will conclude the hearing and go off the record.